Okay, good morning and welcome to the 10th meeting 2014 of the Finance Committee of the Scottish Parliament. Could I please remind everyone present to turn off any mobile phones or other electronic devices. We've received apologies from Michael McMahon this morning. Understood that his substitute Ian Gray is going to be attending committee, but unfortunately he's not here at this time. However, we'll move straight on to our first item of business, which is to continue our Stage 1 consideration of the Revenue Scotland and Tax Powers Bill. I'd therefore like to welcome to the meeting Dr Heidi Poon, who's a Tax Tribunal member and a tax law lecturer at the University of Edinburgh, and Justine Riccomini, who's an independent HR and employment taxes consultant. So a very good morning to you this morning. Now, I understand that there's no statements this morning, so what we normally do is I'll open up with a few questions just to start us off, and then we will introduce other members of the committee who will then ask questions themselves of you. So the first thing I'd like to ask is to yourself, Dr Poon, which is on the general anti-avoidance rule. And Ms Riccomini, you can obviously comment on these when I ask a question to one. Either both feel free to come in as and when you feel appropriate. So what you've said, Dr Poon, is you've said in paragraph 7 of your submission, and I quote, "It is not immediately obvious how a narrowly focused GAR will necessarily confer greater certainty." And you go on to say further on that what is clear is that once a GAR is introduced, the players, i.e. the government and taxpayers alike, are still at the mercy of the courts. And I'm just wondering if I can talk you through your thinking on this, because it's quite different from other witnesses. And as a tax advisor actually said, he found your submission quite refreshing in this regard. So I'd certainly like to hear a wee bit more about your thinking in terms of the GAR.
Right, I have to say I have not read other submissions before I did my own. Yes. So I don't know what other tax advisors have said. But in terms of the consultation, there was a summary saying that people were of the view that a more widely drawn GAR would be creating more uncertainty. I think that was the summary of the views that was gathered at the consultation stage. And my own experience of sitting at the tribunal is, and especially with a long case I've been involved in, involving a tax avoidance scheme, however widely or narrowly drawn a GAR is, you are still having to go through that process of construction of the law, what the law is trying to say, and try to apply it to the facts of the case. So whether it's widely or narrowly drawn, it doesn't confer higher or lower degree of certainty. It's not on that level. The certainty comes from, I would say, a more principle-based approach will give more certainty than whether a GAR is widely or narrowly drawn. So is that clear what I...
Well, I think it is pretty clear, actually. I mean, Ms Riccomini's nodding her head. I'm just wondering if you've got any comments to make on that.
I'm nodding my head because I think it's very sensible what Heidi's actually just said. I think that more focus needs to be put on what actually happens when a problem arises, rather than actually drafting up GARs. I think that's the main problem. It's the practicalities of it when it comes to attending tribunals and things like that.
Okay, and Dr Poon, one of the things you've also pointed out is the fact that, and I quote, "a more widely drawn GAR may result in a reduction of the number of targeted anti-avoidance rules, of which there are some 300 currently in the UK. You said it has grown considerably in complexity and volume in the period of the recent Labour government. There's a correlation between the growth and complexity and the increased number of TARs." So I'm just wondering again if you can talk about how a more widely drawn GAR does actually help, prevent the need to produce all these GARs and TARs.
Right. I think our current UK legislation is characterised by having a very rude, it's based on rules. So you try to legislate according to a set of rules that if you have fulfilled, or certain conditions if you have fulfilled, then you can apply for exemption or get the relief. So the complexity of the legislation itself leads to, if it's more based on rules, it allows people to find the loopholes when you can tick all the boxes, but you may be going against the spirit of the piece of legislation. And because you are ticking all the boxes, you can get away legally avoiding tax. So you come about having some tar. An example I can give you is like in inheritance tax. The current legislation was brought in 1984, and then very soon we have what is called gift with reservation. And it's a set of legislation, it's a kind of tar, because people were trying to gift during their lifetime, but they were retaining the benefits of the asset that they were legally given away. So the gift of reservation suite of legislation came in, and then people started doing other things, and it led to the pre-owned asset charge, tax charge, which is an income tax charge superimposed onto inheritance tax. So this is how the legislation has grown in size and complexity from the original 1984 Inheritance Tax Act. But I think if you start in your legislative design to base it more on principles, it will allow the court wider powers to interpret the legislation and bring within scope what is chargeable, rather than having to circumvent certain schemes that were able to get around the rules, but they were defeating the spirit of the law. So I think it's like the architecture of a design. If you started with rules, you end up having more rules in order to fill the loopholes or to close the loopholes. But if you started with more principles-based approach, there is more scope for a GAR to then come in to interpret the legislation on the basis of principles that is at the base or at the starting point of the design of that piece of legislation. So it does impinge on how other areas of tax is going to be legislated. And I think I've read from CIOT submission is to say that instead of doing a cut and paste from the UK tax legislation, it is an opportunity to think about whether you would consider the basis upon which Scotland is going to have a new way of drafting their tax legislation.
Yes. I mean, to avoid some of the kind of high-profile kind of cases that you personally understand were involved in recently. Yes. I mean, I think you know, what you've said is quite important, and it is quite different in some ways from what other people have actually said. So it gives food for thought to the committee. Again, it was just to see, Ms. Riccomini, if there was anything you wanted to add to that at all.
I would completely agree with what Heidi's just said again, because I think that I think if you've got the opportunity to create a new set of legislation in Scotland, then it should be fit for purpose for Scotland and not just copied and pasted from the UK legislation, because there's so many instances of that where it just doesn't work and it's just not practical in reality. And as a tax practitioner, and you know, having attended tax tribunals myself, etc., etc., there are so many instances where there's just hurdles and hurdles and hurdles. And you know, in the 25 years that I've been practicing tax, you know, I started off with 3 or 4 books that were maybe about this wide, and now I find myself, even just as a specialist employment taxation practitioner, you know, it's like this, and it's gone beyond a joke. And I think that if you can keep it simple and keep it principled, then that would be a more intelligent way of approaching it.
I think also it means that from the public's perspective also it makes it much easier to understand as well.
Yes.
And, you know, because I think they sometimes wonder how some decisions are actually arrived at when, you know, the law might say one thing very strictly, but the clear meaning behind the law is something else, perhaps. Now, just Dr. Poon, again, in your submission, paragraph 11, you said, an omission noted is S212 FA 2013 regarding relationship between the GAR and priority rules. You know, and you go on to talk a wee bit about that specifically, but I'm just wondering what you consider to be the importance of this omission.
Well, I compared the two GARs, the Scottish and the UK, and I have noticed the Scottish GAR is in the bill is drawn very closely in terms of formats and the section headings. They just follow one after the other, albeit that is substituted abuse with avoidance. But if you are following the format, the obvious question is why the UK GAR got these priority rules, and priority rules means the GAR takes precedence over other provisions in the corpus of legislation. So, and the annotated copy of CIOT, well, CIOT produced an annotated copy of the Finance Act every year for their members and associates. So the copy is an interpretation. The annotation is an interpretation of what this priority rules is. And because this is a new piece of legislation, it is as good as what we can rely on. And in applying law, you have to decide which has priority over something when you come into conflict. And here is specifically saying that the UK GAR will take precedence over other priority rules in other parts of the legislation. So say perhaps if a scheme has managed to deploy a priority rule in income tax, but if GAR has judged that it's abusive, then GAR can override that priority rule that has allowed that scheme to be legal in that scope. So if you haven't got that priority rule in the Scottish GAR, and a similar occasion arises, how are you going to resolve it? So that's the question behind my well, I just query why there isn't a priority rule as well, because they, on another level, is with all the double tax agreements. So you can get into an agreement with a contracting state, and then the domestic law has to adopt the agreement to make it in harmony. And sometimes if there is conflict, you have to resolve it. And the GAR has included the treaties as well, as to say if there is conflict, so on the international front, if someone has managed to sort of go in through double taxation agreement to do something which is abusive in the interpretation of GAR, then GAR can overrule that as well. So it's with that I then ask, well, why isn't it there in the Scottish GAR?
Good. That's a point that we will obviously raise with the bill team as we go forward. Now, just going to switch to Ms Riccomini's submission. And you say in paragraph 3 you've concerns about the proportionate ability to pay in terms of the penalty levies and the timescale for the payment of penalties, and this is an issue which other people, of course, have raised. I'm just wondering if you can share some more of your thoughts on that.
Did you say paragraph 3?
No, sorry, it's Ms Riccomini's paper.
Sorry, all right.
Yeah, to do with the timescale for payment. Yeah, I mean, my main concern was really in terms of the fact that current experience shows from the recession, etc., that people, are having difficulty paying, and certainly within 30 days, you know, it's quite a short time frame to arrange the administrative side of it. It's a short time frame to sort out what your assets and liabilities are, if you need to make payment of penalties, etc., etc. If they're in a penalty situation, then sometimes it's indicative that there are wider problems in the business, and it may be the case that they can't afford to pay the penalties, especially within the time frame given, when people are, the cash flow within the business just isn't there, because at the moment, you know, businesses have gone from immediate payment, you know, they're arranging for people to pay over like 90 days or 120 days because nobody's got the cash flow. So what I didn't want to happen was for Revenue Scotland to be entrenched with admin and a huge administrative burden of pursuing debts after 30 days, when there's very little people on the ground to actually put that penalty regime into effect. You know, because this requires, it doesn't just require automated handling. When you're dealing with penalties, it requires a human input, because you can issue automated penalties like Billio, but actually when people start appealing against them, or when people start to submit reasons as to why they can't pay or whatever, then you have to have a human at the other end that can decide upon whether that's a valid reason or a justifiable reason or whatever. So actually I'm just thinking more about the admin burden on the revenue.
Yeah, I mean, I had a company in my own constituency, basically, because of difficulties created under a previous administration of that company, were given 48 hours to pay a huge tax bill, and I was able to speak to them and negotiate that down to 6 months. And the company, which employed almost 100 people, would have went into liquidation and has now managed to survive and is actually thriving. So, I mean, I do sympathise with that requirement. So, what are you basically suggesting then? Are you saying that there shouldn't be a 30-day penalty? Should it be flexible in individual circumstances? What would be the parameters there?
I think that possibly something should be maybe extended to 60 or 90 days. I mean, we're talking about the payment of a penalty rather than the payment of the actual tax itself. So let's assume that, you know, that what you'd like to do is to pursue the actual tax that's due, and are the penalties actually, what do those penalties mean in terms of the actual tax take? Is the penalty really a frippery, or is it just a, you know, I mean, are we talking about pursuing people for, let's just say, I just want to compare it to the collection of the BBC licence fee, for example, where, you know, if you don't pay your BBC television licence, you're awarded a criminal record. You know, it's kind of using a sledgehammer to crack a nut. So what I think is that, you know, if you can think about a way of using a penalty regime to encourage people to pay on a timely basis, but not so much so that it's dragging the entire Revenue Scotland through the mud, and it's like wading through treacle in terms of admin, etc. So I think that perhaps it should be delayed, or the penalties should be structured in a slightly different way.
Yeah, I mean, you have said, you know, that you've kind of repeated yourself there by saying it entrenched the quagmire of bureaucracy as a result of issuing penalty notices, which remain unpaid. But that's assuming there is a high level of non-payment. I mean, is there anything to suggest there would be?
No, it's assuming there is a high level of non-payment. I think you've got to think about whether there may or may not be a high level of non-payment in those circumstances. I mean, we are not talking about income tax here or capital gains or anything like that. So at the end of the day, you know, whether there would be a high level of non-payment in those circumstances remains to be seen, I would say.
Okay. Dr. Poon, do you have something to add there? Well,
from my tribunal experience, since the new penalty legislation coming in Finance Act 2009, quite a high percentage of cases listed are related to penalties. And when you have an appeal on penalties, it does take a lot of administrative time. And in a way, the whole collection process is stalled when you have a dispute. And quite often you see penalties being listed, and it's taking tribunal time as well. These are the cases that are also quite likely to be withdrawn closer to time of the case listed to be heard. So I agree with Justine in that the administrative aspect of penalties can be it can be like disproportionate to the amount that you may end up collecting in terms of time and human effort that needs to be put in. So there is some scope for thought whether, yes, you make it more possible for people to meet the penalty payment. You also have to make it very clear how the penalties are being applied, because you have this kind of escalation, and if you don't get paid, then by a certain time you escalate. And for a business person, it does put a great pressure on the whole cash flow issue. And in a way, you want the tax to be collected, and penalties are there to encourage compliance. And I think someone has said it's not another avenue for the revenue to collect more money. But it is seen that way quite often, just because I think the escalation can be quite aggressive. And very soon, the business find themselves paying 100% of what the tax they were to originally due. And I heard cases where the business said, well, if you do that, I will go out of business, that kind of argument. And those arguments don't have much weight in law in applying penalties, so it doesn't really help them bring the case to the tribunal. So I do think there are some issues to go through on the policy setting level, so that you make it commensurate with the cost you're going to spend to collect the penalties, and you also see it as a means for compliance, rather than another means to just get more tax out of her.
Yeah, so 60 or 90 days, for example, would mean less burden on Revenue Scotland and less burden on the taxpayers, basically.
Yeah, and also it's the communication, because some of the cases brought to the tribunal is the taxpayers had been in penalty and they didn't know about it for another 4 months. Mm-hmm. And they said, this is not fair, you didn't tell me. So it's do you have the administration to get that notice out to the taxpayer in good time to make it a fair assessment on them. Mm-hmm.
Mm-hmm. Thank you very much. I'm going to open up the session now to colleagues around the table, and the first person to ask questions will be Jamie, to be followed by Gavin.
Thank you, Convener. Ms Riccomini, in your submission you say that you agree with the establishment of Revenue Scotland as a non-ministerial department and with its proposed membership. A few folk have come to committee and said that the Chief Executive and other executives should sit on the board, but you don't seem to think that this is a big issue. Can you comment on that? Do you think it's a big issue?
If I haven't commented on it, then no, I don't think it's a big issue.
Okay, that's helpful. Indeed. Ms Riccomini, you also say in relation to the Charter that the bill talks about that Revenue Scotland should adhere to it and not simply aspire to it. Again, a number of people have commented on this seeming discrepancy between what's required of the tax authority as opposed to the taxpayer, but I'm not sure if you're aware the bill team have, I think, accepted that wording's not particularly good and they're going to look at that. I presume you would welcome the fact that they're looking at it.
I would definitely welcome that, yeah.
Okay.
I don't think there should be any discretion as to
yeah, I presume they should place both parties on some form of equivalence.
Yeah.
And you also talk, I mean, you mentioned there earlier that this is obviously a chance to get legislation that's fit for purpose and we shouldn't just copy the UK legislation. In that regard, you mentioned in relation to Revenue Scotland's activities, none of them should be exempt from freedom of information, as some of HMRC's are. I have to confess I'm not particularly aware of what these relate to. I just wonder if you could set that out for the record, what activities are exempt.
There's many parts of the revenues just on a daily basis. Let's say, for example, if you're looking for something in the revenue manuals, or you're looking for something that's in part of the, you might be looking for the answer to a question from a taxpayer, and you want to give them some advice, and you go searching through everything that's online from HMRC. And I am aware that that's being changed at the moment as it's being moved over to gov.uk, because I'm part of the team that's helping out with that. But there are lots of bits of that have been redacted because of the Freedom of Information Act. So it's quite frustrating when you're reading something and then all of a sudden you come across a big bit of it that's actually been taken out, and you're not allowed to see it. Mm-hmm. And frankly, I've never, even when I worked for HMRC, I could never really understand why. When we're talking about tax, we're not talking about GCHQ. We're talking about tax. Why does anybody see fit to redact anything at all? There should be complete openness and complete freedom of information in all aspects of Revenue Scotland's work and HMRC's work, for that matter. I can't see that there's anything that presents some sort of national security issue. If we're asking people to comply, then they need every bit of information that's at their fingertips. And you might say that some of it's been redacted because people, find a way to a loophole or a tax avoidance scheme out of it or whatever. But I honestly can't see that that's the case, because they've already all been thought of.
I mean, I'm inclined to agree with you, actually, but clearly I can't ask you what the redacted bit says is redacted after all. But do you know what sort of areas these matters relate to?
Many different areas. It's not just one area in particular. There's lots of different bits. If you go into HMRC's website and look at, to give you an example, the manuals, quite a lot of the bits have been redacted because of the freedom, and it says this information is not available because of the Freedom of Information Act or whatever. And you just think, why? It's rather condescending and rather irritating, frankly.
I must admit, I'm sitting here thinking why myself, but I can probably explore that as far as we
I'm sure there's somebody out there with a much bigger brain than I've got that knows the answer to that question, but I'm afraid I don't understand it.
Okay. You also talk about the power granted to take samples of material from premises if they are reasonably required to verify a person's...
Witness sometimes.
I beg your pardon. I do apologise.
Yes, I think on the point about information or website manuals, I think one reason why we constantly see changes or things being blocked out, to my mind, maybe just we have this constant change of practice and legislation. With every Finance Act, you are repealing part of the existing corpus of legislation. So I think part of it is we are in this constant flux, and that's why the manuals cannot keep up in good time. So when I don't see something appearing, that's the first thought I had. And then secondly, I think we also need to be careful about the status in law of these HMRC guidances or manuals. When they are relied on, they quite often come to court with the taxpayers, if they have relied on it and found themselves in trouble. They argue that they have ground on legitimate expectations to rely on the accuracy of the manual. So it is an area that the authority and the taxpayers and how they use it, the accuracy of it, whether it's at the right time when it's being used, is reflecting the legislation at that time. it's quite a tricky area to get right. And when it comes to court, when you have the argument of legitimate expectations, you are taking the case onto a different level, not about the tax itself that is in dispute, but whether the taxpayer has the right to rely on these menus to get their situation interpreted according to the menu. So I know Revenue Scotland is developing a website to feed information in, and the background to what this is going to create in terms of relationship between the taxpayer and the authority has to be very clear in mind and managed. And quite often, I think the less said can be the better in these menus, because if you are still developing and changing, you don't want too much reliance to be placed on it to the extent that you create trouble for yourself in the future.
Okay. So the less said, the better, but if you're saying it, don't redact it so we can see what you're saying.
Well, in the sense that you have something which is more permanence, rather than something that you're trying to get so detailed that you have to keep updating it to get right. Do you see what I'm saying?
I do follow. Okay.
Yeah. And that's back to what we were trying to say earlier. If you have a more principles-based approach in your design for tax law, you can end up having something that is much simpler to communicate to the public, as well as it means what you post on the menu doesn't have this kind of transience as we are now experiencing.
Okay, thank you, Dr. Poon. The next point I was going into, Ms. Riccomini, was in relation to the bit you had to say about the power to take samples of material from premises if they're reasonably required to verify a person's tax position, and you suggest that a short list of examples of such samples that might be anticipated should be included. I'm unclear if you mean a list of circumstances where such samples might be required, or the material itself. What do you mean?
No, I actually meant the material, because as an ex-inspector of taxes, I am very aware of people abusing their powers at HMRC in certain circumstances, and placing their own interpretation on what can and cannot be removed from a business premises in terms of, I've got the right to see this and I've got the right to see that. And generally speaking, the people who have visited premises have sometimes taken things that they're not strictly allowed to take. And, it's not really in the spirit of the legislation. So what I'm trying to do there is to maybe try and prescribe some kind of records that, if people go and ask for records, that they are aware of what the limit of those records actually is. What kind of records can be removed, and what do they have to have something to do with the issue at hand, or can they just take anything? Because that has happened in the past, like it or not, that has happened in the past.
Isn't it dangerous of what you propose, though, that if you're suggesting, you're positing that it's a short list of examples, then that could be interpreted as the exhaustive list, and if it's not on it, then you're not allowed to take it. Isn't that the danger?
Yeah, I mean, it was a thought and a suggestion. I don't really know whether I've got any particular solutions as to that suggestion at the moment.
But you do see the point I'm making, that could be a problem, presumably, if it's not on the list, you're not allowed to take it. I mean,
it's in the same kind of context as what I was saying about the taxpayers' charter issue. What we don't want is people abusing their power. That's really what I really wanted to highlight there, was that we don't want revenue officers abusing their power. We need them to stick within the guidelines so that taxpayers and their advisors know where they stand.
Thank you. Okay. Gavin, to be followed by John.
Good morning. First question to Justine Riccomini. Paragraph 9 of your submission, you talk about all ministerial guidance should be fully publicised. I think that's section 8 of the Act. There is an exemption, I think, under subsection 4 of section 8. Can you just expand on your thoughts on that?
Is this under, what's the title of it? Paragraph, what did you say? I don't have numbered paragraphs on my
Right, I think
sheet.
it's paragraph 9 of yours, or it's section 8 of the bill, which is ministerial guidance.
Oh, right. Right, so it's that one. The Independence of Revenue Scotland, is
That,
it
yeah,
one?
that's a paragraph title, but underneath that you make the point.
Yeah.
Yeah, you. Where are we? Yeah, all
Yeah.
interactions with ministers in terms of section 8, subsection 3 should be fully publicised in the spirit of open government.
Yes. Well, that relates to my belief that in order to facilitate a culture where people, well, in my opinion, people should be able to they shouldn't really need tax advisors. I know I may well be doing myself out of a job here, but people should be able to understand and have complete clarity in all aspects of what they do. So, technically speaking, to my mind, the idea of employing a tax advisor on something is because you don't have time rather than you don't understand. So, and I think that should apply to all aspects of taxation. So, actually, with this, I think that it's about having a spirit of completely open government. I think that's the thread that's running throughout my comments, actually, is that, you know, all interactions with ministers as to the running of Revenue Scotland, as I've said, they should just be there for everybody to see. I don't think there's anything wrong with that, and I think it's absolutely, you know, the way that Revenue Scotland should go in terms of the way it needs to function.
Thank you. Dr. Poon, you made the comment earlier that if the GAR in this Act makes future TARs unnecessary, then that would be a positive thing. And I think there's probably a degree of consensus around that. Is there anything that would need to change to the GAR as it's drafted to ensure that end, namely fewer TARs, actually happens? Are there any amendments you think need to be made to ensure that actually happens?
I welcome that question, and I think I would like to take some time to consider that. And my first thought is, GAR is in itself a piece of legislation that interacts with other tax law. It doesn't exist on its own. It is only there to apply to other areas of tax law. So instead of thinking how you draft the GAR to allow future, to reduce the number of TARs in the future, maybe you think about how you draft the next set of legislation to allow the GAR to be more effective in closing, in taking schemes or arrangements that end up not fulfilling the spirit of the law that the new set of legislation is meant to, then the GAR can come in. Do you see what I mean? Yeah, GAR is there for applying onto other sets of tax law. And in order to make the GAR more effective, doing what it's supposed to do, it is the design of your other legislation that is going to make the difference. Yeah?
That's helpful, thank you. Just,
Thank
I mean, as you'll appreciate, we have to produce a report as a committee at the end of the session. So if there were obvious examples, they'd be welcome, but your answer has explained your position quite well, I think.
Thank you. And I may, well, if I think of some good examples, and I'm doing some research in comparing different GARs in different jurisdictions, and when that piece of work is done, I can pass it on to you for further information.
Thank you.
Okay.
And Convener, the last area I wanted just to explore briefly, again, it was from Dr. Poon's submission, disclosure of tax avoidance schemes. I think you were suggesting that you would certainly welcome that being brought into the bill either at stage 2 or thereafter. I wonder if just for the sake of the record you can just outline your position on that.
Right. Well, DOTAS, I think that's how the acronym is pronounced. I have just done a case note for an academic journal on a tax case that was brought to the tribunal because of the penalties involved with a taxpayer using a DOTAS disclosure mechanism. And the decision of the tribunal in that case was to say the penalties are correctly applied because the taxpayers, even though on relying DOTAS, did not discharge their obligations in making an accurate return. They claimed capital losses when there wasn't a transaction to create that loss in the first place. So DOTAS did not exonerate the degree of culpability. But what it did help was to have that openness, and the new legislation that's in Finance Act 2009, the legislation now in place is Finance Act 2007, Schedule 24. And there you were looking at degrees of culpability. And DOTAS, and the categories of culpability, you're talking about being careless and not taking reasonable care, or the second category is deliberate error, but not concealed. And the third category is deliberate and concealed. And by concealment, we are talking about actually create evidence to misguide the tax authority. So if you have these 3 degrees of culpability without DOTAS, the taxpayer will end themselves easily into the more severe offence. But with DOTAS, and if they do make use of it, it will allow the dispute to just rest on the level of being careless. And that will then help with the mitigation of penalty. And I think DOTAS will also allow the authority to know in an early stage what's around. And if you know it is there, you can take a look at it. And the sooner you do that, it means the time spent is not so long, and it's also better for the authority, because sometimes if a scheme is discovered years later, you are into the area, whether it's time barred or not. So for multiple reasons, I think to have GAR and DOTAS, that they should go hand in hand.
That's helpful. Thank you. Thank you.
John?
Thanks, Convener. I think probably mainly to go back over some of the things that were mentioned, some of the interaction between yourselves and the Convener at the beginning were of interest, and especially this area of principles in legislation that I think you both suggested that you quite like the idea that it should be principle-based rather than incredibly detailed rules. I mean, we've had suggestions from some witnesses that actually the UK legislation is moving in that direction. So, I mean, in the first place, is that your feeling that actually the UK is moving in that direction? Because I do believe other countries like the Netherlands have a more principles-based approach. Well, I'm happy with either, but Ms. Poon, if your light's on. If you like.
I can't remember which piece of legislation that started off in that direction, but then ended up going on the rules-based again. Yes. I think it's one of it's to do with employment scheme or something, and then it did it may be the disguised remuneration.
Right.
I'm not exact.
No, that's
here.
okay. I mean, I don't need
Yeah.
the exact case, but I mean, you're kind of hinting that you're not convinced that the UK has moved very far.
Correct. Yeah, I think there was the attempt, but it did not carry through. But the problem also is, I think you're trying to graft something. If you have it more principle-based, but you're grafting onto the bigger corpus of legislation, which is not designed that way.
Yes.
And how do you allow that grafting to be successful? I think that's where the joint is failing. And I go back to David Tweedy. He during his time as the chairman of, I think it's the International Accounting Standard Board, he motioned, or he moved this approach to allow international financial reporting standards to be more principles-based. And that was like a decade's work. But the merit of that is it allows the IFRS to be more manageable in size, because you are not trying to do it the US way, where you're trying to just think of all possibilities, all scenarios, all contingency, and make a complete set of rules.
Yes.
And his approach, I think, has also allowed kind of what we call comparability. And it's so important for global economy, because if an accountant or an investor is trying to make a decision about two companies in different jurisdictions, and if they haven't got comparable standards in their accounting reporting, how are you to know that one company is doing better in one area than the other? So the principle is based when it has got the adherence of more countries. That allows people to compare two sets of accounts. Yeah. And if you think you are doing it on rules-based and each country has its own set of rules, it does make life incredibly difficult.
Yes, I mean, I take that point. I think that's good. That's good. The argument for principles, which applies both to companies and obviously to countries as well. Now, where do you see this bill as fitting in there? Is it? Do you think it's more principles based? It's meant. I mean, it's claimed to be.
I think this bill, as it is quite similar in what we are getting in the UK tax legislation. Would you not?
Mr. Riccomini, sorry, do you want to jump in or anything?
Yep. I didn't read it. I thought it was a reasonable start, a reasonable place to start. But as we've said, and I don't want to repeat, it maybe needs to look at things in a slightly different way, almost in a more philosophical way, rather than trying to sort of, it's like Heidi said, if you try and think of every single scenario that somebody could possibly ever avoid taxing, you're on a losing streak before you even start, because you can't think of everything that everybody's ever going to do, because they'll always find a way around it, because that's what, tax advisors are generally employed to do. But I think that certainly in terms of the simplicity of the regulations, if they were more principled and rather than trying to be too prescriptive, that would be a much better place to start. And I think that probably it would be a good idea for the Scottish Parliament to consult with people like the gentleman that Heidi's just actually mentioned, and also the Office of Tax Simplification in England as well. There's a guy called John Whiting that I have a lot of dealings with at the Office of Tax Simplification, and I'm on a committee of national employment tax experts that sort of, when we're working with the Office of Tax Simplification to look at how to change employment taxation completely going forward, to just make it easier to administer, etc. Because with all the share schemes and the expats and everything else, it's exceptionally complicated. But also it would bring about possibly some sort of consistency of reporting with different, with companies, with individuals. Making it simpler would almost make it easier for everyone. And just to add to that, the point that you made at the beginning, I'm not sure that the simplification of the tax regime in the UK at the moment is necessarily working, because what we seem to be doing is, by trying to simplify everything, we're just making it more complicated, and it's just growing arms and legs,
right,
when in actual fact we need to be chopping off the arms and legs and trying to just keep it contained. But again, I think it's because we're still trying to tax everything that moves rather than look at it from a more philosophical point of view.
I mean, personally, I've got a huge amount of sympathy with what you're both saying, although we have had other witnesses here at the committee who have said, yes, we like the move, a bit of a move towards principles, but we don't want to be too different from what the UK is doing, because some taxpayers are operating in both systems and they might get confused if we're too different. Is that a danger?
I think if it's simple enough to understand, then we are here talking about, you need to be perhaps quite radical in rethinking. And an example I have is, I think in Hong Kong, I may not be right, I have left the country for many years, but I think Hong Kong, being a small country in landmass and all that, the tax system is based on territorial tie. So in terms of international tax law, you either get the nexus to tax a source of income because it happens to be in your jurisdiction, it arises in your country, or you tax according to the residence of the person. So most jurisdictions will have a mixture, and then you end up having double taxation relief because a source can be taxed in one country, owned by a person resident in another country. And Hong Kong, for being a small place, and I think there is another jurisdiction, they operate just territorial, which is source-based tax, is to say, well, we don't think about where your residence is. So you take away a suite of legislation to determine where a person is resident, and you just tax the source of income, whether it's employment, whether it's corporation, whether it's consumption, as arising in the territory. And it is simpler to administer because you are just dealing with one nexus rather than having the complication of another nexus coming in, source and residence, and then you decide who has the right. And when it's competing, you have then another set of rules to decide how you are going to give relief and how you are going to give primary right to which country. So it can be a very effective model for a smaller jurisdiction like Scotland. And you will also eliminate all the questions as to, well, if a person is both a resident in Scotland as well as in England, how are you going to tax this person? Yes. And that is opening a floodgate of determinations and whether we have the resources to deal with it when it's such a common occurrence when people can just change their residence to suit their tax bill.
I mean, I think you're raising some big issues here, which probably should have been raised before the bill was written, let alone...
But I think it's in the second stage where, well, I have talked about, like, Guy and all that, is how you apply to other tax legislations. So it's in thinking about the new law you're going to pass to bring in a new tax regime for Scotland. I think that's where you can think about how you use the principles-based approach.
Okay, well, I don't want to go on too long, but I mean, one other point, I think, especially Mr. Riccomini, you mentioned was the idea of openness, and there should be more openness, and you're not happy with the present system. I mean, we have heard of other countries where everybody's tax return gets published, And some countries even, I believe, give their top 10 taxpayers a prize at the end of the year. Would you be wanting to be down that complete openness route? Because there is an argument to say that every taxpayer is paying to the state, therefore every taxpayer should have all their tax returns published.
I'm not sure about the human rights side of that or the privacy side of that, but I think perhaps that would need to be thought about before we go to that level of openness. I think perhaps what we need to think about is if Scotland has got the opportunity to raise its own taxes and have its own tax jurisdiction and make its own legislation, then it could really do something revolutionary rather than just following what everybody else is doing. And I think that actually, you've got the ability at the moment to be able to draft legislation in a different way because it hasn't really been done yet. So as you're only at the tip of the iceberg, as it were. I think that also gives Scotland the opportunity to present itself as an exceptionally open and honest government and open, absolutely transparent, etc., which is so important these days. That's really what people want to see. I think it's half the reason people don't turn out to vote. I think it's half the reason, companies think twice about whether they want to invest in a country or whether they want to employ people here, because, not here anyway, they just need to kind of understand what that country is all about and how it works and how it functions. And I think if the people who live here and who are within the jurisdiction of this country are able to see that, then it could potentially attract new business to Scotland. It could attract a different level of compliance from its people and actually create a new culture within this country as well that doesn't exist in the UK at the moment because everybody is so disenfranchised.
Okay, that's very helpful. That's very interesting. Thanks so much. Okay.
Thank you very much. That's exhausted the questions from the committee. Just one further question that I want to raise, and that's in terms of Dr Poon's submission. In terms of paragraph 16, you've said there is little in the bill to suggest what the criteria for selecting a mediator are. I'm just wondering if you can give us some suggestions as to what those criteria can perhaps be.
I think competence in the technical aspects will be one important criterion. So you are actually getting someone who understands the text that is in dispute and can understand both sides and their arguments. I'm probably thinking about something that is a little lower than the tribunal, but it has the same kind of robustness in technical judgment. So the mediator cannot be just the mediator needs to be conversant with the tax law. So that's one aspect, and that gives credibility as well to the decision. It has to be independent so that it's not being appointed by the revenue. So independence, technical competence, and experience in adjudicating. Yeah.
Okay, thank you for that. Mr. Riccomini, do you have any comments you want to make?
No.
Okay, just before we wind up the session, are there any further points you want to bring to the attention of the committee at all?
About tax law simplification, I think the statistics I was once given by John Whiting coming to speak to the Tribunal Judges Conference. He gave the figure that they removed 100 pages of tax legislation in 2 years, And in those 2 years, Parliament added back 1,000. So
I saw in your notes, actually, you've given quite extensive details with, in terms of the orange and yellow handbooks. You said the publisher, LexisNexis, states that the 2012-13 Tolley's orange and yellow handbooks, 18,634 pages, and then you go on to explain all the different kind of non-statutory material, excluding this, excluding that. I mean, it's even going through that itself is complex enough. Just looking at,
yeah.
so it's quite mind-numbing, and quite clearly that it's almost impossible for anyone to have a full grasp of that, if indeed it is possible. I certainly doubt it. So I think the issue of simplification is one the committee certainly grasped.
But yes, that's sort of back to the question, how successful that has been with tax simplification. I think it's hard to work with something that has grown to that size and you try to simplify it, because you can't work on the foundation. And here in Scotland, we have a chance to work on the foundation, to make the foundation a different structure that will not grow in that shape. Yeah.
Okay. Well, thank you very much for that. And on that note, we'll end this particular session. I'm just going to allow brief recess to allow change of witnesses and to give members a natural break. Thank you. Okay, folks, we're all here, and I'll start off with agenda item 2, and our second item of business today is to take evidence from Association of Personal Injury Lawyers and the Faculty of Advocates as part of our scrutiny of the Courts Reform Scotland Bill's financial memorandum. I therefore welcome to the meeting Ronnie Conway of the Association of Personal Injury Lawyers and James Wolffe QC of the Faculty of Advocates, who members of the committee will remember came here in a slightly different capacity just a short time ago. Now, there's no opening speeches, and I'm sure you both know how this works. I'll start off with some opening questions and then widen the session to include colleagues in the committee, one of whom's already got their name down to ask the first question from the committee. So, without further ado, I'm just wondering if I can ask Mr Conway the first question. Now, when asked questions, please feel free to comment. So if I ask a question of yourself, Mr Conway, Mr Wolffe may or may not wish to come in, and vice versa. Okay. You've said in paragraph 3 of your submission, Mr Conway, that APIL has recommended a limit of £30,000 based on evidence collected and arguments outlined in the evidence to the Justice Committee. And you go on to say, we refute absolutely the assumption that paragraph 75 of the financial memorandum that only 80% of personal injury cases will move to the Sheriff Court as a result of this bill. I'm just wondering if you can give us a wee bit of information of your estimate of what that figure really should be.
Yes. If I may begin, with the permission of the committee, by talking about the figures which the government has used. And it goes back to the Civil Courts Review. And the critical figure here is not the sum sued for, it's the settlement figure. Lawyers routinely inflate or exaggerate, if you wish to use that phrase, the sum sued for, because the court cannot award more than you ask. And it's a nightmare of practitioners like James and myself to have a judgment which would say, I would have awarded such and such, but the sum sued for was such and such, I cannot make that award. Now, which means that the sum sued for is routinely about a third higher than the real value of the case. And if we had known, if the profession had known that the civil servants were going to place such emphasis on it, we may have adopted a different approach. But the fact is, there were two sets of data originally. The first was that they looked at cases involved over a 2-week period, and they looked solely at the sum sued for. And they found that on a certain scoping, about 1/3 of the cases would downshift to the Sheriff Court in the light of the proposals. The second set of data was produced by one insurer who responded from their own files. And if I can say to the committee that everyone, I think it's fair to say that everyone who looks at this data has looked at it with considerable reservations and caution. If you look at what's said in the SPICE briefing about it, you'll see that it's not clear as to whether this is a truly representative cohort. And further inquiry was the proponents of the bill seemed to me to want further interrogation of this data, and they were told by the government that that was not possible for reasons of confidentiality. And whilst one can see that confidentiality might well attach to the names of the parties, it's difficult, those could easily be redacted, and it's difficult to see on what other basis confidentiality could operate. But to get back to the point, APIL commissioned their own research. It was done by a firm of law accountants called Alec Quinn and Partners, who routinely act for both pursuers and defenders. So they are not holding the ring for any particular constituency here. And they looked at, I think it was about 5 or 6 firms who specialised in court of session work. And the firms were told to put all their cases in for a period of 1 month. And those cases were followed through to the outcome. And there was a cohort of 53 cases. The details have been sent to the government, and they were attached to the submission to the Justice Committee, which heard evidence yesterday. If one looks at the the figures which we have, which we would suggest are far more robust and reliable, can be interrogated. The only confidential aspect would be the client's names. Other than that, we are quite happy to make full details of these cases available. Out of those 53 cases, only 2 resulted in a settlement of over £150,000. So what you're looking at is not an 80% downshift, but a 95 or 96% downshift. The Civil Courts Review appears to have a fear that somehow pursuers' firms will subvert whatever legislation is made, so that somehow they will simply exaggerate the sum sued for and get a ticket into the Court of Session that way. That is the reason they say that the figure of 150,000 should be as high as it is. It's much higher than any other jurisdiction in the United Kingdom. It's much higher than the Republic of Ireland. And they seem to suggest that a pursuer's firm could do this with impunity. But that, I have to say, is a misconception. It's a misrepresentation of what the current situation is. Because at the end of the day, the basis on which costs are awarded depends on the settlement figure. Just to give an example on the present system, there was a case which was heard last week in the Court of Session where the sum sued for was something like £15,000. It settled at £6,500. The case is Brown v Sabre, and the decision of Lord Boyd was that effectively the settlement figure indicated that this case should never have been brought in the Court of Session. He reduced costs on the basis that it should have been raised in the Sheriff Court. He reduced that there would be no sanction for counsel. Now, without knowing the personnel directly, you may take it that that firm will not behave in that way again. And there is no doubt that there must be behavioural change. The proponents of the legislation are absolutely right to say cases must get shifted out of the Court of Session because too many low-value cases are in the Court of Session. Too many low-value cases in the Court of Session. The limit is too high because they go straight from low value to high value. There is nothing, as I said yesterday to the Justice Committee, modesty is relative in every walk of life. But I would suggest that if you asked your constituents, is £50,000 a modest sum of money? Is £150,000 a modest sum of money? They would look at you as if you were mad. So, on the scoping which we've done, we think that the government has consistently underestimated the downshift of cases. We further think that they have overestimated the settlement rate of cases. The current settlement figure in the Court of Session, when it was checked last, and there was research done in 2008, is that 98% of cases, 98 out of 100 cases, settled, mainly at the door of the court. There are procedural drivers for that settlement process which do not exist in the Sheriff Court. The first is that there has to, the availability of counsel. And it's not our position that there should be automatic sanction for counsel. We think counsel should be sanctioned in appropriate cases, but the fact is that they are a driver to settlement. There is a face-to-face compulsory meeting. There is a no excuses, no adjournment culture in the Court of Session, whereby 4 days are allocated, and you've got to be ready to turn up, be prepared. There is the example. There is a case example in the written submission to the Justice Committee, which shows an analogous case, a low-value case in the Sheriff Court in Hamilton, which bounces around. Only 1 day allocated at the start. It starts. 2 or 3 days are further required. They're allocated about 6 months in advance. The day before those 2 or 3 days is due to the 2 or 3 days is due to commence. the parties are told that a jury trial, a criminal jury trial, has run over, and the sheriff is obliged to deal with that. It then has to call twice as a procedural hearing to get further dates allocated. The whole evidence-taking and submission procedure took over a year. Now, every practitioner in the Sheriff Court knows that it is creaking under tremendous pressure. And to pass this law, to pass, best part of 2,600, 2,700 cases down without additional resources, and I wish to make that plain, this is about funding and it's about resources. Our concern about the government's projections is that they appear to be throwing sixes at every point of the process. So we say that they are looking at the most optimistic downshift numbers. They appear to have ignored the April figures. We say that they are looking at the most optimistic settlement figures. If we are right, or even on the government's figure of 80%, which we think is an underestimate, a difference of rather than 98 out of 100, if it were simply being 90 out of 100, 85 out of 100, you would need at least another 5 or 6 sheriffs. I'm conscious that I'm speaking here without written material. Since we've seen the financial memorandum, we have been working on some kind of scopings and projections, and would be happy to make these available to the committee if that were to be of any interest.
Thank you very much, Mr. Conway, for that detailed answer to my question. Mr. Wolffe, you will have comments to make. Obviously, people have suggested that the limit should be £30,000 on evidence collected. I'm just wondering what your view of that faculty of advocates would be.
If I might just pick up on one or two of the points that Ronnie's made. First of all, on the issue of the data upon which the bill is based, the discussion of the statistics in the SPICE briefing is at page 19, and it's based essentially on a comparison of 93 Court of Session cases and 94 Sheriff Court cases over a period of 3 years from one respondent. And to be fair, the Civil Court Review itself, in a footnote which is quoted in the SPICE briefing, recognised the statistical perhaps limitations is an underestimate of that data. I don't know what the numbers are, but over a period of 3 years, there must have been thousands of cases going through the system. So I think it's perhaps as well to appreciate the limitations of that data. Looking to the £30,000 figure which has been suggested and the impact that would have, again, picking up on Ronnie's observation that one should really be looking at the settlement figures rather than the sum sued for. We've produced some data in our response to the Justice Committee, which was made available to us, a cohort of just over 1,000 cases raised in 2011 and 2012. And on that cohort, if one took the cases which settled for £20,000 or less, that represented 70% of the cohort. So if one's looking at settlement value as the relevant figure and one's looking at £20,000 on that cohort, then one would be taking 70% of that cohort out of the Court of Session and into the Sheriff Court. So that gives the committee a sense of the scale of what can be achieved at significantly lower figures than the 150,000. And just to amplify Ronnie's observation about the how the court deals with the reality that the sum sued for will often exceed, and sometimes by some margin, the figure at which a case settles, for perfectly proper and good reasons. The bill itself contains a obligation on the Court of Session to remit to the Sheriff Court any case where at any point it appears to the court that the value of the case, assuming liability and assuming no contributing negligence, is lower than whatever limit is fixed. And as I understand what's envisaged, it's envisaged that these cases will call at an early stage before a judge. A judge will look at the case, and if the judge takes the view that on the most optimistic view, the case is not worth a figure over the exclusive competence limit, then it will be sent to the Sheriff Court. And in addition, there's the pressure which will be brought to bear through the way that expenses are dealt with. So in the personal injury field, the figure of 150,000 it seems way out of, way beyond what is necessary. There is a point that I would like to make about the non-personal injury cases, because the driver for this part of the bill is very much the phenomenon that, by reason of the efficiency and effectiveness of the way the Court of Session handles personal injury cases, we have a significant volume of cases at the lower end of the value scale being raised in the Court of Session in the personal injury field. In the non-personal injury field, the proposal is to apply the same 150,000 limit. I'm not aware of any evidence that in the non-personal injury field, and particularly looking at commercial cases, that these are, there's any case to be made that cases are being brought inappropriately to the Court of Session on any view of matters. And one of the concerns that we have is that if one looks at the non-personal injury field, and particularly the commercial field, there's a real risk that cases that really, that we're going to compel commercial litigants and other litigants who, for good reasons, choose to come to the Court of Session at the moment to bring cases in their local sheriff courts. We recognise, as APEL does, that an increase in the figure is appropriate, and like APEL, we suggest that a figure which equates to the figure in Northern Ireland, 30,000, would be appropriate. And I may say that figure in Northern Ireland was increased from 15 only last year, February last year. And the Northern Ireland comparison is an interesting one, because in Northern Ireland, if the case is worth more than 30, it has to go to the High Court. So it's actually operates in a different way.
Mr. Gibbs, may I just make one supplementary point, because I'm listening to Ms. Wolffe. I'm conscious that I may not have answered your question properly. We started off at looking at the shape of the Court of Session as described in the Civil Court Review, where Lord Gill, the prime author of the review, said that after the reforms there would be 65% of cases in the Sheriff Court, 35% of cases in the Court of Session. It seemed to us, and it's that would retain the Court of Session as a court of first instance, and I will not repeat what was said to the Justice Committee yesterday as to why that is an important thing. So what we looked at was a figure which would, first of all, if you like, commend itself to the public, but secondly, and perhaps more importantly, would meet that projection, namely leaving the Court of Session with about a third of the cases at first instance. And there's a histogram attached, or a scattergram, in fact, I'm told it's to be described as, attached to the submission to the Justice Committee. And it's perfectly clear from that, and it's based on settlement figures, that £30,000 would do the trick.
I'm glad there's some unanimity on that. That's quite clear in terms of what for the committee going forward. I mean, the financial memorandum notes that the number of cases heard at first instance at Sheriff Court levels decreased by 36% since 2008-2009. Now, obviously, Mr. Conway, you talked about the Sheriff Courts in your quote. You actually use the phrase creaking at the seams, and of course you emphasised that just a few minutes ago. So surely if with a 30% reduction there is greater scope perhaps for dealing with such cases in the Sheriff Court, which is why of course neither of you are disputing the fact that some of these cases should move to the Sheriff Court. It's just about the level at which they should go to the Sheriff Court.
Well, I suppose there's really a number of things I would say to that. First of all, I practice both in the Sheriff Court and in the Court of Session. I appreciate it's only on an anecdotal level, but the Sheriff Court is under huge time constraints. The analysis in the Civil Courts Review was that the current legal system is slow, inefficient and expensive. And too expensive. That analysis only applied insofar as the first two matters, slowness and inefficiency, to the Sheriff Court. The Court of Session is too expensive for low-value cases. There's no dispute about that. It's a Rolls-Royce system otherwise. The problem about the 30% reduction is that you need to look at the makeup of the cohort of cases. It seems to us, looking at the civil judicial statistics, that in the Sheriff Court, probably around 50,000 of those cases are debt cases or repossession cases. And the reality is that those cases do not really consume judicial or they consume administrative resources, but not judicial resources. So that anything which is of substantive, such as personal injury work, will involve a significant input of judicial resources. So, in fact, I saw one comment from one of the government officials saying, well, this only represents 3% of the cases overall, so how can that possibly make any difference? Well, the answer is that the numbers coming down, 2,500, will require the cases which do not settle, and I'll not repeat what was said already about the figures on that, but the cases which do not settle will first of all require procedural input, because there will be motions, particularly there will be motions for sanction for counsel, which will now be a matter of routine. These do not appear to me to have been factored anywhere into the figures. And there will be 4 days of proof, 4 days of proof allocated. So all that would need to happen is for a clinical negligence case, for example, which routinely runs to 8, 12 days, or a long-running personal injury matter involving some disease case, for example, and the system would be completely overwhelmed. So I appreciate, I've seen what the statistics say. There is a reduction in litigation generally, but concentrating on the top figures really doesn't do justice as to what is happening on the ground.
Mr. Wolffe?
Yes. The first thing I would say is that we unequivocally support the need for improvement in the way that the Sheriff Court operates, particularly for contested and more complex litigation. And I'd, from the information I received from my members, I would endorse what Ronnie has said. One general concern about the context of the present bill, much of which I unequivocally support for precisely that reason, is that the ultimate vision for improving the way that the court operates is a shift to what's described as active case management. And in the SPICE briefing, that's described at pages 8 to 9, which involves more active judicial engagement with cases. And I have a general concern about how that is going to be achieved against the context of a financial memorandum which doesn't suggest that there is to be any more resource put into the system. And if one's thinking about the Sheriff Court dealing with additional cases and thinking about that 3% figure, it's again, I think, important to distinguish between personal injury cases and the others, because the expectation is that for personal injury cases, they will go to a new national personal injury Sheriff Court. And we can look at the proposed resourcing of that court, and I suspect Ronnie's better placed than I am to speak to whether the anticipated resourcing of that court is going to be adequate. But if one looks at the non-personal injury cases, one thinks, say, of the commercial case, and on the civil court review figures, it was about a quarter of the cases at that point being brought to the commercial court that would be below the 150,000 limit. These are cases that have been brought to the commercial court, one anticipates, because the pursuer, or in some cases both parties, may have been taken the view on advice that the nature of the case, the issues involved, the likely complexity of the dispute made it a case that was suitable to bring to the commercial court. Now, the implication of the bill is that those litigants will be compelled to take that case to whatever local sheriff court happens to be the right local sheriff court for the case. And if one starts from the assumption that these are cases which are likely to be at the more complex end, they're likely to be more difficult, they're perhaps, one suspects, likely to be contested. These are precisely the sorts of cases that the Sheriff Court currently, as I understand it, doesn't handle terribly well. Now, I don't want to tar the whole Sheriff Court system with the same brush, and it's by any means, but there are problems, and they're not going to be helped in individual Sheriff Courts by moving these cases to those courts. Ultimately, though, I'm concerned about those litigants who currently choose, for good reasons, to come to the Court of Session for the particular service that that court can provide, who are going to be compelled at a time when everyone accepts that Sheriff Court reform is a process that's going to take 10 years and investment if it's going to realise the aims, that they're going to be compelled from the outset to take their cases to the Sheriff Court.
I realise time's marching on, and I want to allow colleagues around the table to come in. I've got numerous further questions to ask, but I'm going to restrict myself to one to enable colleagues to come in. So the question is with regard to Mr Wolffe, your own submission again, which is, you said that, and I quote, the estimated impact on the legal aid board is unlikely to be accurate, from paragraphs 94 to 97. So I'm just wondering if you can tell us what you believe the impact will actually be.
Yes, I think the first point to make is that the overwhelming majority of personal injury cases are not funded out of public funds. They're essentially, in the Court of Session at least, as I understand it, the Pursuers Representatives act on a speculative basis, which is a no-win, no-fee basis, and those are not supported by public funds. So, as I understand it, and it's fair to say I suspect Ronnie's better placed from a personal point of view to speak to this, the legal aid board, the legal aid funded cases tend to be the clinical negligence cases, the ones that are more complicated, the ones that for one reason or another aren't being supported through the speculative mechanism. Now, the Legal Aid Board, I think, rightly, is quite cautious in the way it puts the estimate. It says, if I recall it, that the saving could be up to 1.2 million. And they rightly say, they observe that that's likely to, in a sense, kick in only over a period of time. The question I ask is, if the board is currently supporting the more complex and difficult cases, these are the very cases where it is one would have thought, likely to be true that the involvement of council will continue to be justified. And so I think there must be a question mark, at the very least, about the validity of the assumption that there'll be a 50% saving.
Mr.
Sorry. May I?
Yes, I'm just going to on this particular point. Actually, I mean, you've said that the cost and the financial memorandum are barely penciled, but on the particular issue that I've asked about the legal aid board, I'm just wondering if you can respond.
I'm very grateful to you, because a constant problem that I've got to say that APL have with these figures is that I'm reluctant to be too dogmatic about matters, because we don't appear to have access to the backstory research, so to speak, for want of a better expression. But let me say that the idea that £1.2 million will be saved to the public purse is complete smoke and mirrors. If there is a substantial saving, it will be to the insurance industry. The Legal Aid Board does not pay. I look at the figures, I think it's from 94 to 97 in the financial memorandum. The Legal Aid Board does not pay £2.4 million to the Faculty of Advocates. What happens, except in an accounting sense, it's an accounting protocol. As Mr. Wolffe indicated, and as the figures show, at least 9 out of 10 of these cases is successful. The Legal Aid Board say 85%. They complain that they get dumped with the hardest cases. So if 85% of the hardest cases are successful, you can imagine what's happening with the rest of them. As an accounting protocol, I sue Mr. Wolffe in his capacity as an insurer, for example. I get £100,000. I'm legally aided. I get £25,000 of costs. I have got to send that £25,000 of costs to the Legal Aid Board, who then pay it back to me as fees. So that the true figure, and as far as I can, again, the caveats are in the written submission. Looking at the figures in the financial memorandum, £4.9 million in total was paid out by the Legal Aid Board. That is not a net figure. That is not a net. They have not the true cost of the whole reparation budget on that basis is 15% of that, namely £735,000. And of course, the Legal Aid Board have a whole stringent list as to when legal aid might be available. First of all, in the Court of Session, legal aid is only available if you meet quite stringent requirements that the case is worth more than £50,000. So they're the gatekeepers as far as that's concerned. In the Sheriff Court, there's a whole... the test, I can say both in theory and in practice, is much, much tougher. So the idea that even out of that £735,000 there will be savings to the public purse is illusory. In my view, it is completely wrong. And it is, I have to say, really not acceptable for the Legal Aid Board to suggest to people here and in the Justice Committee and to the wider MSPs that there will be a saving to the public purse. There may be a saving in the sense that counsel in some modest, in low value cases will be excluded. But the saving will be made to the insurance industry, not to the public.
Thank you very much for that very clear response, Mr. Conway. I'm now going to open up the session. The first person to ask questions will be Malcolm, followed by the Deputy Convener.
I mean, I was going to structure my questions around cost first and then savings, but since we've started with legal aid, which I was going to, since we're on legal aid, which I've asked about, let's just do it the other way around and see if what savings we can actually establish from the bill. I mean, clearly you're saying the legal aid savings will not materialise, as I understand it, for two reasons, because there will be a recovery of costs issue, and there will also be the fact that counsel will still be required. I mean, perhaps this is to Mr Wolffe, but I mean, to what extent do you think there will be less use of counsel as a result of the changes, or do you not see a significant change in that regard?
So far as the legal aided supported cases, it's hard to see. I mean, of course, it's difficult because one doesn't know, as Mr Conway says, precisely on how the figures have been reached. I suppose our basic point on this is that, as I understand it, legal aid in the personal injury world is supporting the more complex cases, and these are likely to be the cases in which counsel will continue on any view of matters to be required if they're to be properly conducted. It is fair to say, I think, the board does say in its response to this committee that it recognises that there will be recovery of costs, and they are quite cautious in the way they put it. They say the savings in a full year could range from 800,000 to 1.2 million. And they also say that they may be lower in the first few years. But I just have a question mark about how robust any of these numbers are, given the nature of the cases that they're supporting.
So if we look at the Sheriff Court first in this regard, I mean, Mr Conway has suggested that they're already under pressure, and therefore this is going to put more pressure on them. But in terms of the costs and the staffing, so is the assumption that you make, Mr Conway, that there will be additional costs required as far as the Sheriff Court is concerned? I mean, are you assuming that more staff will be required, or? Well,
my understanding from looking at the financial memorandum is that existing administrative staff will be deployed. So as far as there seems to be some suggestion that Court of Session clerical staff might be downshifted to the Sheriff Court and be paid about less. I'm not sure what they think of that, but that's what the assumption appears to be. So from an admin support situation, we don't have major concerns about this. We have major concerns about the IT support. The Civil Law Review was scathing about the technological situation in the Sheriff Court. If any of you ever visit your own local Sheriff Court, we're barely in the analogue age, never mind the digital age. One of the big advantages in the Court of Session is the what's called e-motions, electronic communications with the court, electronic communications between parties, immediate procedural decisions sent out to the parties, electronic recording of evidence. And we are dismayed, to put it no higher, to find that the whole IT budget for the new Specialist Personal Injury Court, and also, if one thinks of, there also be 16 Specialist Personal Injury centres, so to speak, in the various sheriffdoms, that the total IT budget for that is £10,000. It seems, again, there is no backstory to this. On the face of it, it seems an extremely economical estimate.
I wonder if I might just add on the question of pressure on the Sheriff Court that you have a very short submission from the Sheriffs Association which expresses concern about what they say, that the pressure of increased business on the Sheriff Court has been underestimated, and they point to other pressures that may be coming their way arising from the abolition of corroboration, and perhaps one doesn't want to get into other areas of controversy, but it's worth looking at the very short submission that you have from the Sheriffs Association. And I should just, Mr Chisholm, if I may, just pick up on your question about the use of counsel. I took that to be directed specifically to the legal aid number. There's, of course, a much broader issue, which is the impact which the shift of business into the Sheriff Court may have on counsel more generally, and the loss, ultimately the loss to pursuers who currently have the benefit of counsel acting on a speculative basis, of the ability to instruct counsel in practical ability to instruct counsel in personal injury work. But I didn't understand your question to be going to that, but more to the legal aid number.
So in terms of sheriff numbers, is your assumption, Mr Conway, that there will actually be a requirement for additional sheriffs in the sheriff?
Mr Chisholm, I should have said that to you the first time round. On our scoping figures, we're going to need between 4 to 6 additional sheriffs, depending on what the downshift is and what the settlement figures are. Our suggestion is that there should be a specialist personal injury court in Edinburgh and also in Glasgow. It would need to be funded by the government would need to take into account additional judicial salaries at the sheriff rate. But we may say that we've no argument with the idea that summary sheriffs would result in a saving to the government. At present, it appears to be on a kind of one person in, one person out basis, so there will be no significant short-term saving, but the scoping over 10 years appears to us to be right. And in many respects, I have to say that the idea of a third judicial tier is a masterstroke, and even as a standalone measure should be implemented. But if we start off from the civil court review, which identifies precisely the problems with the legal system which exist in the sheriff court, and then say, here is another 3,000 cases, no new resources, no IT funding, to say that that is counterintuitive is to put it at its mildest.
So are you saying you'll need these summary sheriffs plus extra sheriffs?
Plus extra sheriffs to deal with the ordinary cases. Yes, Mr Chisholm, thank you.
So in terms of possible savings, again, turning to the Court of Session, I think at one point at paragraph 83 it talks about using personal injury sheriffs would save money as against judges, but I mean, is there any proposal to reduce the number of judges in the Court of Session as a result of this legislation?
Well, may I say that is an excellent question. The financial memorandum seems to scope in some kind of judicial saving, but as you pointed out, Mr Chisholm, there will be, while the number of judges is the same, there will be no judicial savings. And it does seem to me that if scoping, and some scoping has been done for the summary sheriffs being introduced over a 10-year period, that it would not be difficult, given that all judges have a specific retirement age, to spell out what the intentions are for the Court of Session. Because if the same number of judges are sitting there, there will be no savings in the Court of Session. And I have to say, it would be of some interest, I think, both to members of the legal profession and the public at large, to know what the proponents of this legislation have in mind for the Court of Session. Is it to be 35 judges over the next 10 years or so? Both the policy memorandum and the financial memorandum is silent on that, and it is something which we should know.
And you say in your own submission there will be a loss of fee income from personal injuries cases to the Court of Session, so presumably that could be a financial problem as well.
This is the major black hole in the financial proposals. The figures which we've obtained, APL have obtained under Freedom of Information, show that the total fee fund income, that's the amount that parties pay to get, it's the price of admission, so to speak, to get into court. The total is, for 2011 and 2012, I'll just use those figures, they're more or less representative. The total is 4.6 million. Out of that, personal injury contributes something like 2.3 million. So it's 50% of the fees fund dues. The analogous figure in the Sheriff Court for a similar number of cases is £804,000. And again, I would be happy to provide, to send details. A Court of Session case, on average, generates for the Scottish Court Services about £750. a sheriff court case, on average, generates about I think the figure is £238. There is a huge difference if you're multiplying that by 2,000 or so cases. We have calculated that the fees fund loss to the Scottish court services will be just short of £1 million. This appears nowhere in the financial memorandum. There is a hint of a suggestion that the reforms will be financed by fee income. And am I being unduly cynical in thinking that all that will happen is, or that what will happen, is that the sheriff court fees will have to be more than doubled to make up for the loss of the fee income? Doubled for a product which I would suggest is of markedly inferior quality. But whether that is right or not, we should know what they've got in mind.
Okay, well, thank you very much.
Thank you, Mr. Chisholm.
Good job we've got the Bill team following on, isn't it? Because we'll be asking some of these questions to them. John.
Thanks, Convener. Mr. Conway, in your paper, now I don't know if it's maybe just I think it's a typographical error, but I've got paragraph 10, I don't know if your paragraphs were numbered that way, under savings to the Scottish Legal Aid Board. Yes, indeed. And I just think there's some millions in there that might not be the right figure. Like in the 5th line, it talks about 6,337 million. Now, my suspicion is it's 6.3.
You're quite right, Mr.
Is that correct? And there's a few figures like that, so
yes,
maybe
indeed.
just for the record.
Yes, indeed. Yes,
we can have that.
I'm grateful to you for that.
That's okay.
Thank you for reading that into the papers.
Dots and commas and things like that.
Yes.
On the area, I mean, on IT, which has been mentioned already, there's the suggestion that actually we should invest quite a lot more in IT, and compared to other areas of life, 10,000 does seem very small. I mean, could some of that be self-funding, that shorthand writers presumably come at quite a cost, and over time there would not be an extra cost, there would be a saving if we invested in IT?
Yes, we want investment in IT, and at present, you're absolutely right to make that point. At present, in the Sheriff Court, all matters over £5,000, parties have got to employ and pay for a shorthand writer. The legal aid fund, because I mean,
so who would make the decision to change that and put in a lot? I mean, is it government money? It has to be the government takes the initiative, or is there some other way that could be changed?
Well, it has to be the government that takes the initiative. They've already done so in the Court of Session. They spent a considerable amount in upgrading the Court of Session a few years back. There needs to be electronic recording equipment provided. Pardon me. The present position is that parties pay for a shorthand writer. I do not think it could be workable that parties would pay for electronic recording of evidence. Mm-hmm. So we think. I mean, again, I go back to my original position that we cannot be too dogmatic about it, because they might just say, well, we've got the existing case management system in the Court of Session, we will just transfer that over to the specialist personal injury court. There's no further cost. That's a possibility. It doesn't say that, and it also doesn't deal with the equipment problems and the other 16 specialist centres, so to speak.
Okay. I mean, we've had the comment already that the court system as a whole is slow, inefficient and expensive, but that the slow and inefficient bit is the sheriff courts. We've also had the statement that I think it was a clinical negligence case which was referred to takes 8 to 12 days.
Yes.
And I'm not sure if that's in all types of courts. I mean, I'm just wondering if that has changed over time, because, I mean, other professions and cleaners and everybody has to do things quicker than they did 20 years ago. And we're being told that the sheriff courts are under considerable pressure. I mean, are things done quicker than they were 20 years ago, or is it just the same?
That's a big question, Mr. Mason. It's something that I've never actually... I've been in practice for over 20 years. Are things exactly the same? The problem for the kind of work which a personal injury case involves, it's first of all fact-based. That there has to be an interrogation through examination and cross-examination of witnesses of factual questions. Then there's certainly, as I'm speaking on the hoof here, so to speak, there has been an injection of expert evidence into this area of work at all kinds of levels. So experts talking about health and safety, experts talking about medical situations. It's much more complicated now. And of course, that's the reason that the Civil Courts Review talked about specialisation. So if you ask me, are things done any more quickly, the answer is no, they're not done any more quickly.
Because I suppose my concern is, and I'm not from a legal background, so I'm speaking as an outsider, but I mean, we see pressure on costs right across the board.
Yes.
People are in hospital less than they used to be. They stay one night, they used to stay 4 nights, all of that kind of thing.
Yes.
And before I was recommending more money to any of this, I'd want to be convinced that really costs are being pushed down, things are being done more efficiently than they were in the past, things are being speeded up, because everybody else in life is speeding up, and I just wonder if the courts and the legal side have got left behind.
It's certainly an interesting point, Mr. Mason. I'm not trying to dodge it, but I will take refuge in the analysis in the Civil Court Review, which did not see any basis for the kind of speeding up process which you've described. It doesn't really exist in any other jurisdictions, I've got to say.
Portuguese lawyers as against Scottish ones or anything?
No. Sorry, I should say UK jurisdiction.
Right, okay.
So there's no. Perhaps it's an interesting point, and it's something which I'm conscious. I haven't really given it a great deal of thought, and as I say, I take refuge in that better minds than mine have spent a lot of the time analysing the system and have failed to find the kind of savings which you've described, Mr. Mason. Thank you.
So, Wolffe, do you want to?
Yes. Can I say that there have been substantial changes in certain parts of the system, and they perhaps illustrate that sometimes a great deal can be achieved by reform in the way that we go about things. I can think about the personal injury field. The Chapter 43 procedure, which is the specialist personal injury procedure in the Court of Session, as I understand it, works extremely efficiently. One of the reasons, as I understand it, why that works extremely efficiently is that a timetable is fixed right at the outset of the case, and part of that timetable includes a compulsory meeting ahead of any hearing of evidence at which the parties are expected to come along and talk about the case. And again, Mr. Conway can speak to the practicalities of it. My understanding is that has been a very effective way in encouraging cases to settle at an earlier point. One of the proposals, which is currently on the table for personal injury work, is the introduction of what's called a pre-action protocol, which is in effect compulsory procedure that parties need to go through before they ever raise an action, again with the aim of encouraging cases to settle at as early a stage as possible. And in particular, the pre-action protocol, for example, could create an environment in which, if defenders see that there's merit in the case, one would expect and hope that they would settle the case promptly, avoiding the expense of litigation, if that's what they're wanting to do. In the Inner House appeal court procedure, there was a period of time, not all that long ago, when, as a practitioner, one would have to say to clients, once it's in the Inner House, it's going to take far too long before you get to a hearing. The Inner House has substantially, at least certainly the perception of the profession is, the Inner House has substantially improved that through a series of practical procedural reforms around front-loading the work. It's not necessarily cheaper to the litigant. A lot of work is now done early in the process of an appeal in terms of, or earlier in the process of appeal in terms of drafting notes of argument and preparing the papers, but the aim of that ultimately is to save time in court. And my impression is that that's been very effective. So there are things that can be done and which have been done and are being done to make the court part of it work more efficiently. They don't always save costs to the litigants, and the inner house reforms are a good example of where you save time in court, but you actually load the cost in at a different stage in the process. So,
positive to me.
Absolutely.
Because if we're being told that the sheriff courts, it's the court time that's clogged up, then if you could repeat that process in the sheriff courts, we might make some progress.
Well, I think it would be wrong for the committee to get the impression that it's all just an antediluvian Victorian system in which nothing has been done or can be done. Things have been done, are being done, and so far as the sheriff court is concerned, the civil court review has a vision of a sheriff court working much more effectively, using specialist sheriffs, using case management, and the third judicial tier, as Ronnie says, is a masterstroke in terms of, as it were, dividing up the kind of specialisation of the business. The question I think one has to ask, particularly when one's looking at the active judicial case management of cases, which will necessarily involve more judge time in looking at a case at an earlier stage, the question one has to ask is whether that can really be achieved in a budget that's remaining constant.
And the practicalities from what you were saying earlier seem to be that because the sheriff courts are dealing with a mixture of cases, and if a criminal one goes over, that just throws the whole system.
Well, there is a very important point there, which at some level, I suppose, is the elephant in the room of the civil court proposals, which is that our courts deal with criminal business and civil business. And for very good reasons, criminal business has to be given a degree of priority in the system. We're very proud of our time limits for the swift dispatch of criminal business, and one would hate to see those change. That has an impact on the ability of the system to deal with the civil business, and it's a difficult management exercise, which those within the system do very well in handling. But it is a real part of the system that if you've got a sheriff who's sitting doing a criminal trial, well, until the criminal trial's finished, he's not available to do something else.
Understand that, Mr. Conway?
Yes, I'm very grateful to my friend because he has reminded me of what I should have known already, namely that since antediluvian days, there is first of all pre-action protocol. At present it's a voluntary scheme. Parties have got to opt into it, but most insurers are in favour of it, and almost all claimant lawyers are in favour of it, and it involves, before any court action is raised, if you like, a cards on the table approach to what the case is about, and it's extremely successful. The recommendation from the Civil Court Review is that it should be compulsory, and my understanding is that the Civil Justice Council will be taking steps to make it compulsory. APL are absolutely in favour of that. So there's that first sift, if you like, which is looking to prevent cases ever getting near a court. Once they get to the court, the technical answer is what's known as Chapter 43 procedure, which is what was introduced in the Court of Session, I think around 7 or 8 years ago, which again, there's no judicial case management. It's what's known as a case flow model, but parties have got to put their full case on the table. There are no trial by ambush, no surprises. There has to be a face-to-face settlement meeting, and that is what has achieved the 98 out of 100 settlement cases in the Court of Session. And the government carried out research, I think, Elaine Samuel research, evaluating procedure, evaluating Chapter 3 procedure. I appreciate that's a kind of technical answer, but we do things much better than we did 20 years ago.
And I think it is perhaps important just to notice that the government has established the Scottish Civil Justice Council precisely to drive all of that through, and we're wholly supportive of these sorts of reforms.
Thank you. Gavin.
Thanks. Most of my issues have been covered, but just the last one was the Faculty of Advocates say at paragraph 12 of their submission, the involvement of counsel can facilitate settlement of cases, and it is possible that more cases will in fact run to proof if counsel are less frequently used. I just wonder if is there any empirical evidence of that? Is there anything you can point the committee towards to sort of back that up as something that may happen if counsel are indeed less frequently used?
I think all that I can say is that, and I should say I don't personally practice in the field of personal injury, but it is reported to me that we now have in the Sheriff Court, in effect, the equivalent of Chapter 43, and it's reported to me by my members that hasn't replicated the same level of efficiency and the like as one has achieved in the Court of Session. And part of that, as it's reported to me, is around the culture of the way counsel go about dealing with cases. You know, if counsel involved in an early stage, they'll identify the key issues, they'll identify the evidence that's required, they'll advise what investigations are required, and then if you've got skilled counsel who are experienced in the field talking to one another, they all know exactly what the law is, where the issues are, and you know that process of experts who understand exactly how the system works, talking to another, facilitates settlement. But Ronnie's probably better placed than I am.
Well, I think it's a very good question. Is there empirical evidence? There is no empirical evidence one way or another. Interestingly, the author of the research that I just mentioned, Elaine Samuels, suggested that the Sheriff Court, for reasons outlined by Mr Wolffe, would not achieve the same settlement levels. But my feeling is that they don't, but I do not have empirical evidence. No one has.
Thank you very much. That appears to have concluded questions from the committee. I'm just wondering if there's any final brief points you would like to make before we wind up the session.
I think there's just perhaps one point to make. The question of, and I appreciate the committee's been focusing on the costs and savings to the public purse. One of the issues, of course, has been the, as it were, the cost to litigants, and it's simply to notice that the Table 3 in the Spice Memorandum, which sets out figures looking to the ratio of total expenses to value of settlement in the Court of Session, that one hits, and if one looks not to the sum sued for, but to the average value of the settlement as the relevant figure for the reasons we've already discussed, that one gets to a disproportionate, or to a figure where the costs involved start to exceed the value of the settlement at a figure below 20,000 if one's looking at the value of the settlement rather than the sum sued for. And of course, one always has to appreciate when looking at those figures that there is, to an extent, a fixed cost in running a case at all that one has to factor in. So inevitably, as one gets to the lower value end of the case, the ratio of what the case has cost to the value of the case is going to be greater.
Thank you, Mr. Conway.
The only final point I would wish to make relates to the Sheriff Appeal Court. And in a sense, it's part a policy point, but also a finance point. At the time of the Civil Court review, the suggestion was that there would be an appeal court which would have a bench of 3 sheriff principals to deal with appeals from the Sheriff Court. It would be an all-national appeal court, and it would be very, very difficult to take a further appeal from that appeal court to the inner house of the Court of Session. Now, and the Civil Court review said that this would provide a quality appellate structure which would involve a body of persons, 3 minds being better than one, at minimal cost and expense. And what we see in the proposal is that the 3 Sheriff Principal Appeal Court has disappeared. We are now talking about an appeal to a single person who does not even have to be a Sheriff Principal, but may be a Sheriff of 1 year standing, and that an onward appeal from there to the Court of Session will only be granted in exceptional circumstances, and that further the business operations or business exigencies in the Court of Session is a factor as to whether that appeal will be allowed to go forward. Now, it seems to me that someone has crunched the numbers on these proposals somewhere. They do not add up, and we're looking at cheese pairing right across the board. And that is, quite apart from the, you will take it that I do not think, as a matter of policy, that that is acceptable. But I think that is an illustration of the difficulties which the proponents of this legislation have in finding a financial basis for it. I'm very grateful to you.
Thank you. The committee is very grateful to both of you for your comprehensive evidence today. Thank you very much. I'm now going to call another short recess for an actual break for members of the committee before we start our final session of the morning. Now continue your consideration of the Courts Reform Scotland Bill, Financial Memorandum, by taking evidence from the Scottish Government Bill Team. I'd therefore like to welcome to the meeting Cameron Stewart, the Bill Team Leader, Jan Marshall, Deputy Director, Civil Law and Legal Systems Division, and Ewan Bruce, Finance Division. And as there is no statement from the Bill Team, we will go straight to questions. So as is usual with the circumstances, I will ask the opening questions and then we will open the session out to colleagues around the team. So, first of all, I mean, you've heard much of what was said in the previous session, if not all of it, so I'm going to ask some questions based on that first of all. And the first question is in relation to the additional burden, if one wants to put it that way, on the Sheriff Court system. The very brief submission from the Sheriffs Association, which is referred to, says that the abolition of corroboration and the move towards a reduction in level discretion afforded to the Crown in relation to marking cases is likely to result in a significantly greater increase in the number of prosecutions as is currently estimated. Now, we know the Financial Memorandum talks about a 36% reduction in cases over the last 5 years. With that notwithstanding, we're going to have a situation whereby there are almost certainly going to be additional cases through abolition of corroboration and also from this piece of legislation. So how do you feel that the sheriff system is going to be able to cope, and what will be the cost implications of this legislation on that?
Thank you, Convener. First of all, I think the 36% reduction we talk about was to do with the civil caseload in the sheriff courts, and obviously corroboration and the criminal justice bill affects the criminal caseloads. It still impacts the sheriff court as a whole, of course. Obviously, because we're the civil court reform, we focused on the civil caseloads, and that's why we put that information into the financial memorandum. In discussion of the criminal justice bill, and I know you took evidence from them as well, the increase we've seen was not fundamental. I think it was a 6% increase in a solemn and a 1% increase in summary crime. So we didn't see that take into account the reductions that were discussed about in terms of the civil caseload as having an effect really on the management of business within the sheriff courts.
Okay, so, you know, when APIL say that in order to transfer work effectively from court of session to sheriff courts, that would really need another half a dozen or so sheriffs, you don't accept that?
No, we don't. I mean, the cases that are coming out of the court of session, the vast majority of those will be heard, we expect to be heard in the new sheriff specialised personal injury court. And so they won't really be affected by criminal business, because that would be a kind of separate court dealing only with that personal injury business. So we don't accept that would require further resource.
Okay.
Can I just pick up on a point there, Convener?
Of course.
We heard the evidence earlier this morning from Apple and from the faculty as to, there was a lot of discussion around settlement, and I think what is important is to have a sense of perspective as to the volume of cases that are likely to have to be processed through the Sheriff Court, and in particular the volume of cases that are likely to come to proof. We've heard this morning that approximately 98% of cases raised in the Sheriff Court settle and don't come to proof. Of those, if we refer to the financial memorandum, it's anticipated that with the reforms, around 2,700 cases may be passed on to the Sheriff Court. All of that, around, I believe around 2,000 of those are cases, are personal injury cases. But the probability is that the vast majority of those cases are likely to settle. The present figure proceeding to proof in the Court of Session at the moment is, I think there's around 30 proceed to proof. I think that's in the financial memorandum. Yes. Yes. And at present, the volume of cases going through the Sheriff Court, of those, we believe, given stats from the Scottish Court Service, it's less than 4% of the cases proceed to proof. So in terms, I think it's important to keep a sense of proportion as to the volume. There will be a substantial amount of volume transferring from the Court of Session. It doesn't represent a substantial volume given the volume of cases already in the Sheriff Court. And I think it's also worth mentioning that at present 67% of all personal injury cases are already heard in the Sheriff Court. And the other point I would make in terms of volumes and the ability of the Sheriff Court to be able to cope with an increase in volumes, I think it has to be again put into context that it's not simply a case that what the reforms are doing is to transfer a substantial volume of cases out of the Court of Session for good reason. What the reforms will also do will drive up efficiencies. There are proposals to introduce, as we've heard, case management system. We'll hear more, anticipate, on what is proposed in terms of IT systems. The idea is that we will increase efficiencies by having judicial continuity. The Sheriff Court rules will be changed to accommodate these efficiencies and better management of cases. We're introducing, proposal is to introduce the summary sheriff system, which will allow cases to be dealt with at the appropriate stage, the appropriate tier of the judiciary, which is appropriate to the value and complexity of the case. So I think it's important that we can't simply look at one aspect of the proposed reforms in isolation, because all of the other proposed reforms will impact and help to deliver what the objectives of the overall court reform agenda is.
Thanks very much, actually. That was a very helpful response. Now, in terms of the privative jurisdiction, which is going to be retitled the exclusive competence, that's going to be changed from £5,000 to £150,000. As I quote, a pragmatic driver to shift business from the Court of Session to the Sheriff Courts. But you've obviously had evidence from the Faculty of Advocates and APIL, who both believe, for the reasons I've explained, that some £30,000 would be a better parameter. I'm just wondering why you specifically picked that £150,000 and what your response is to the evidence you've already heard in terms of that.
Well, Lord Gill, in his review, one of the main drivers was to transfer business, a substantial part of business, out of the Court of Session, and with the key aim of removing lower value cases out of the Court of Session, since it's thought that that's not the appropriate forum for those cases. And what we have in the financial memorandum is at table 12 is our different models based on where you set the limit, and it was felt that cases of a value in excess of 150,000 would move a substantial part of business from the Court of Session, which, as I say, is the intention of the reform.
Okay.
Can I add some?
Yes.
Just to add to that, I think Jan touched on it in a previous answer, that the figures, the 30,000 figure that APIL used, and I think the faculty in their response as well, was based on the settlement figure at the end of the case. Our figures are based on the sum sued for the figure at the start of the case. And that was used as making an obvious way of where the case was to go right at the start, when the pursuer was suggesting how much the case was worth for. So I think we're comparing two slightly different things if you're looking at the sum sued for the settlement fee. We've certainly based our exclusive competence and our reforms on the sum sued for figure at 150,000.
Why did you pick that route?
Because you wouldn't know what the case would settle for at the start of the case. You wouldn't be able to pick the forum for where the case should go at that point. The only figure you really have is the sum sued for, which is why that figure was chosen as being the basis for making that choice.
Okay. Now, in terms of fees, also you'll have heard in evidence given this morning in terms of sheriff fees that the loss of fees could be of the order, it's been suggested, of £1 million. The £750 fee to Court of Session is effectively transferred to Sheriff Courts, where Mr Conway suggests it's about £238, and therefore the only way to actually bridge that gap would be by my arithmetic, a trebling of Sheriff Court fees. Although if you're saying that 67% already dealt with there, then perhaps you're not talking about trebling overall, but you could be talking about still a significant increase across the board of sheriff's fees, which would obviously impact on the 2/3 of people who go to the Sheriff Courts at the moment. What's your view on that, and in terms of that particular impact?
Sheriff Court fees are set through SSIs, or court fees in general are set through SSIs at the moment. The last ones went through in 2012, setting the fees for the next 3 years. They're based on historical decisions taken for the fee levels recommended by the SES and ultimately agreed by the Scottish Parliament. Now, the SES are looking at fees post-reform and just at the general 3-yearly cycle for court fees, and there will be consulting, I think, at some point next year, I would assume, on the next level of fees, so they'll be taking that into account in their future decisions. So as I say, fees are set based on SES's, modelling work, SES's decisions, put to public consultation and then brought to Parliament to vote on. That will continue to be the case. We don't know, given the different business levels, what changes that might have effect on future court fees, but that will be fully consulted on by the SES at an appropriate time.
I mean, surely the point that Mr Conway was making, and that I certainly want to make, is that if you're actually transferring business from the Court of Session to the Sheriff Court and therefore losing those fees effectively to the public purse, how do you actually make a saving to the public purse if in actual fact the transfer, because of reduced fees, at least in the as things stand at the moment, would be of the order of a seven-figure sum?
I haven't looked at the April figures in detail, so I don't want to comment on them.
But I mean, it's just in general. Surely, if people aren't going to be paying fees to the Court of Session, and they're going to be transferred to the Sheriff Court where the fee is less than a third of what it is, there must be an impact on the public purse, because in each instance the fee is £500 or so less, and you multiply that by the number of ones transferred, there's going to be an impact on the public purse, surely.
The fees are used to cover the costs of the cases. So the assumption is when you're going down to Sheriff Court, the cost of that case is lower, therefore the fee itself is lower. Now, obviously there are some static costs in terms of estate and stuff that have to be covered by fees. And so in a future fee round, that may have to be looked at. But we don't see this having a substantial effect.
Okay, fair enough. Now the other point, another point that was made, obviously, in evidence this morning, and this will be my final question before opening out to colleagues, because there's lots of questions I think colleagues will probably want to ask and follow up on some of the things I mentioned in depth. It's, the April have said in their evidence that, and I quote, there seems to be no correlation anywhere with the figures in the financial memorandum which say the board paid out a total of £4.9 million, of which £2.4 million was actually paid to council. That refers to paragraph 97, and Mr Conway suggested that the real figure paid to council was of the order of £735,000. So it's just how did you come to your figures? Because obviously we want to reconcile these different viewpoints.
I think we have to make the point quite clearly that the figures are provided to the Scottish Government by the Legal Aid Board. In working on these reforms and in preparing the accompanying documents, we've worked with our justice delivery partners and specifically in relation to the contribution on legal aid. It has come from the Legal Aid Board. I think it was said quite fairly in when from the evidence we heard this morning that the figures provided by the board are set in quite a tentative way, and in their supplementary evidence to the committee, in the written evidence have made clear that there could be a range of potential savings. But those figures, as I say, come from the Legal Aid Board. So it may be if the committee would wish further information on the specifics of that we could either arrange for the Legal Aid Board to write, or the committee could write direct to the board.
Okay, thank you very much for that. So I'm going to open out the session to colleagues. The first person to ask questions will be Gavin, to be followed by Malcolm.
Thank you. Were our previous witnesses correct when they said that court fee income wasn't covered at all in the financial memorandum?
We did cover how the reforms will be funded in the financial memorandum, not in great detail in terms of the level of fee income. But just give me 2 seconds. Paragraph 26 is where it starts with court fees. It's a section that outlines how these reforms will be funded. As I said, the last court fee orders went through in 2012, and as part of that process, there was an extra 1% increase on top of inflation rate, which was agreed by the Parliament, and that 1% increase is what's been used to fund these reforms.
Okay, but in terms of the impact of this particular bill on court fee income, does what the witnesses earlier had to say have some resonance. Their contention was that there would be a loss of approximately £1 million per annum to the court structures in terms of fees if fee levels were unchanged. I mean, have you looked at that? Does that figure sound accurate to you? Is it miles off the park? What is the Bill team's official position on that figure of £1 million that was said to this committee?
Well, we did look at the level of court fees in terms of what the effect on the parties would be, but they are correct that we hadn't looked at this in terms of the effect overall on the public purse, and therefore I don't have the ability to say here right now if that £1 million figure sounds correct, but I'll have to get back to the committee on that.
Okay, I mean, is that a commitment that you will? Because
yes,
I mean,
definitely.
In terms of Table 2 of the financial memorandum, in terms of potential recurring costs and savings, it seems to be pretty much that everything is a saving, apart from the initial judicial structures, which is an £8,000 cost, and the Crown and Procurator Fiscal Service, which is a £29,000 cost. So if it was a £1 million loss per annum, that would be pretty significant in terms of potential recurring costs and savings.
Yeah. I think I would like to say that obviously fee income reflects the court case that had taken place at that time, so to recover the costs of that case. So I don't think it would be as stark as that. But
yeah, can I just add that again, we're reliant on a third party, on again one of our justice partners. It's the Scottish Court Service who have to provide us with the information on fee income and their funding. And paragraph 31, as I said, the financial memorandum, which was prepared in collaboration with our partners, makes clear that what we've been told by the Court Service is that the current fee income is on track to ensure that the costs of reforms can be met. So if additional information is required about the impact of the reduction in the overall fee income and the impact that would have on the delivery of the reforms, we would have to go back to the Scottish Court Service on that.
Just for clarity, is that something then the Bill team will provide to the committee?
yes.
Yes.
Okay, thank you. Thank you. Next question is we heard evidence, and again it's mentioned in the financial memorandum, the IT set-up costs for the personal injury court were set at £10,000. Now, witnesses suggested that figure was low. Can you explain to the committee how that figure was reached?
Yeah, in terms of that £10,000, that is just to update the current database, just to make sure it can be used. However, there's a separate project undertaken by the SCS to totally revamp the civil IT systems across the Sheriff Court estate, and that's separate to this bill, so it wasn't pointed out. It wasn't covered in the financial memorandum, but it's a separate part of the reforms that are being taken forward through Making Justice Work.
Okay, so in terms of the changes brought about directly by this bill, the only IT costs relative to the personal injury court would be £10,000.
It's minor upgrades to the current IT system, while this new one would come on stream at a later date.
Yes, as Cameron has said, the reforms that have been taken forward in this bill are part of a wider reform agenda that the Scottish Government is participating in, along with Justice Delivery Partners. And as Cameron has mentioned, it's the overall programme is Making Justice Work. And part of the Making Justice Work strategy, there's a work stream dealing with a digital strategy. And the Court Service have, as I understand it, very ambitious aims and objectives in introducing IT and reforming and refreshing their IT system. And so far as I understand it, it's a multi-million-pound investment is being done in that. So again, it takes me back to my original point that we can't just look at a particular aspect of the reform in isolation. It has to be looked at in the round. The reason why we'll be able to deliver efficiencies is because, as I say, other things are happening elsewhere as part of the overall reform package.
Okay, thank you. Next question. The convener asked the question about why £150,000 was set at the threshold, as opposed to, say, the £30,000 that was suggested by other witnesses. If the threshold had been set at £30,000 instead of £150,000, what impact would that have on the financial memorandum?
so I'm just looking at the table. We didn't look at under £30,000. You see the table 12 in financial memorandum sets out that at £50,000, at a level of 50,000, only 960 cases would be affected. So that'd be a huge difference in the 2,000, obviously, that affect 150,000.
But again, I think, as the point was made earlier by Cameron, the Scottish Government position and the basis upon which we're proceeding is the value of the claim as raised in the court action. The evidence that was given this morning proceeded on the basis that it would be the settlement value of the claim. So we're not comparing similar things, not dealing with similar things.
Okay. But if you, sorry, just to add on to that, if you weren't to take as many cases out of the court session, then there might not be the business drivers to have the specialist personal injury court. If there's not enough cases for that court to work with, you wouldn't get the savings that would come through from moving that level of business. So it is one of the major reforms, moving that substantial amount of business from the court of session to the sheriff court.
Okay. And lastly, if I may, convener, table 5 of the financial memorandum, which is just after paragraph 41. I've got page 58, but I don't know if everyone has the same numbering. And this is just in terms of, I guess, the costs of sheriffs or the judicial deployment within sheriff courts. Your figure for sitting days is 29,135. Now this is based on 11-12 deployments. And you've got various scenarios of splitting it between sheriffs and summary sheriffs. But regardless of how you do that, the number of sitting days would be 29,135. Am I correct in thinking that? Right. If you add in then, in terms of the number of additional cases going to the sheriff court, what's your central scenario for that?
Again, that could be looked at in terms of declining civil caseload. And we're moving 2,700 cases down, but for instance, last year I think there was just under 8,000 less cases in the sheriff courts. So it's a small number of the majority of sheriff court cases that are heard. Also, in terms of sitting days, a lot of these we've already heard from the previous panel won't get to the stage of getting to a court case. I think it's 30 we suggest in the financial memorandum is what we expect to get. So on the modelling we've done with the Scottish Court Service, we don't expect to be any requirement for an increase in sitting days to deal with that level of transfer of work.
Okay, but just a specific question, in terms of your central scenario, how many cases do you think will be transferred to the sheriff court?
From the court, from the
court session,
yeah.
under your central. I mean, obviously you've got various models. Your kind of central projection is how many?
Yeah, we think about 2,500.
2,500. Okay.
Yeah.
So your position then, if I hear it right, then is you could transfer 2,500 cases down to the sheriff court, but the overall number of sitting days would remain the same at 29,135. Yes.
Yes.
There'd be no impact on the number of sitting days.
No, because the level of business is going down anyway, and the number of cases that actually get to court is very small. So as I said, the modelling we've looked at does show that there's no requirement for an increase in sitting days. Sitting days aren't generally driven. This is a question the SCS will be able to give you more information on in terms of the business planning. But sitting days aren't generally driven by the total number of cases. It's more the cases that get to proof stage and other things that go to it. So their modelling work suggests that level of business would be handled within those sitting days.
Sure. No, I just wanted clarity. I mean, I'm not an expert in the matter at all. It struck me as counterintuitive that you can transfer that number of cases and it doesn't even increase the number of days by one. That's your position.
So I think, again, it has to be borne in mind that things will be done differently. The personal injury cases that come out of the court of session, the anticipation is that those will go to the new personal injury court and that there will be increased efficiency. It's not that we're drawing down 2,500 cases from the court of session and putting them into the existing structure within the sheriff court. As I say, there are all sorts of other reforms and to increase efficiency.
Okay, I'm grateful for that. Thank you.
Just before I let Malcolm in, there's been a theme so far in terms of my own questions and Gavin's about you've responded, that this information has come from a third-party partners. But I mean, obviously the bill team has to come here and answer questions from the Finance Committee, and the third-party partners don't. What steps have you taken to interrogate the figures that have actually been given to you by these third-party partners? Because in terms of the issue of fees, there's clearly a gap, I think, in terms of the sums that we've been discussing. So I mean, you just asked them a question and they've come back with something, you've said that's fine, or what? How have you ensured that those figures that have been given to you are robust?
We've worked with partners throughout the last year in building up business cases for the different parts of the reforms, and we've worked with the Scottish Court Services Office and the Scottish Legal Aid Board as well over a long period of time building up these business cases. And it was those business cases that fed into this. I agree that on the fee income is one part we need to get a bit more information on. We're drawn, but the rest of it we're happy to answer to any questions to this, although for the detail, any extra bit of detail, any background work, we'd probably have to go back to the partners, but we did interrogate, we did work with them and drawn up this information. We haven't just received information and included it without being involved in the...
So it's just that the overall, you know, if you look at the overall finance of the financial memorandum, the fee issue seems to be quite significant. You know, it's not a few £1,000s. It's a huge chunk in terms of the potential saving to the public purse. That's why I'm particularly concerned about that particular area.
I say we're happy to look into that in more detail and get back to the committee as soon as possible on that.
Okay.
And just to emphasise the point yet again, that the thrust of the reforms isn't, the driver isn't the savings to the public purse. The driver for the reforms is to improve efficiencies and improve access to justice for the court users.
Okay, thanks for that. Okay, Malcolm to be followed by John.
I mean, I can accept the last point that Jan Marshall made. Obviously, our job in this committee is to try and work out what the financial implications of them are. So just resuming where Gavin left off, I mean, am I summarising your position correctly if I say, in spite of the extra work going to the Sheriff Court, and the previous witnesses said quite a lot of that would be complex, you're saying you can have the same number of staff and can actually substitute sheriffs with summary sheriffs over the next few years? Is that your basic position?
That's position, yeah.
And so this significant savings in Table 5 on page 58, that's because of summary sheriffs taking over from sheriffs, is that right?
That's right, yeah. Different salaries.
So that's £2.4 million.
If you went to a 50-50 split, that's not a plan.
And are you absolutely confident in terms of equal pay legislation that you will be able to pay summary sheriffs significantly less than sheriffs?
I think what we've set out is it'll be set by an independent, the Senior Salaries Review Board will set the limit. We've looked at what they currently have for an equivalent judge in England, and it's the lowest grade on the scale. We expect that's where they would place, given the jurisdiction and the competence of a summary sheriff, that's where they would place that role, which is a tier below the sheriff. So that's what base our planning assumptions on.
And have you taken legal advice on that?
I mean, we're comfortable that this independent body will put forward a salary that is sensible for the summary sheriffs, and once that happens, we'll look at that in detail.
Now, one of the major critiques of the financial memorandum from the previous witnesses concerned the assumptions on legal aid, and I suppose they were questioned on two grounds. One, that they didn't seem to take account of recovery of costs, which covered a large part of it. And secondly, there was an assumption that half of the legal aid payments to council would disappear, and again that was questioned in terms of what would happen in the Sheriff Court. So what would your response be to those points?
The Legal Aid Board, as you know, put in the evidence to this committee as well. They're confident, and as are we with them, that these do include the recovery aspects and the other issues that were raised. They have taken all this into account when building up this figure that they came to between 800,000 and 1.2 million.
So you've just accepted that figure from the Legal Aid Board? And
we work with them, but they are the people who hold that data, so they're the ones able to find that figure. But have they taken
account of the recovery of costs aspect in giving you those figures? Have they taken account of the recovery of costs?
Yes.
Yes, in their evidence they've said that they've taken into account contributions, recoveries and judicial expenses. I mean, they have explained in their evidence that making assumptions, they have to necessarily make assumptions when doing their forecasting, and it can be particularly complex in legal aid cases. But they do make the point that they don't always make a recovery.
But they usually they do, yeah. And what about the assumptions about half of the legal aid payments to council? What's that based on? not, disappearing, as it were.
I mean, they have looked at the cases that they expect to be in that transit would get transferred, and then the difference in what the council cost may be in those. So they have to try and, I mean, as they admit within their submission, it is fairly complex and have to make a lot of assumptions, but they have tried to look at the cases that would be affected, how much that cost them, and how much the savings may be made from that.
Now, what about the future of the Court of Session? That's obviously part of the cost. I raised this to the previous witnesses. Are these 34 judges still going to be there but not doing quite as much as they did before?
The level of judges will be reviewed over time, as probably currently the case, the way business works. There's no policy incentive at the moment to reduce the number of Court of Session judges, but that will be a constant review process as things go forward.
And the fee income being reduced for the Court of Session, is that a problem for the Court of Session because of the loss of the personal injury fee income?
I mean, I'd say we'll get back in more detail on fee income, but what I will say is fee income is obviously based on trying to recover the costs of the case. And so if you have less cases, you'll less need to raise that income.
Yeah, but you've still got the costs of the
You've
Court
still
of
got
Session
static costs, yeah, indeed. And as I say, we'll get back in more detail.
Well, I mean, last point. I mean, Gavin Brown obviously covered quite extensively the issue of fee income, but can I just try and be clear in my own head, because I'm not quite sure what your final position was at. So there's going to be a loss of £1 million of fee income. Are you? Is that? Do you basically believe that it will cost less to do all of this in the Sheriff Court, or are you actually going to have to? If the fees stay the same, is there actually going to be some cost to the public purse there, or is your assumption that it's just going to cost £1 million less in the Court of Session than in the Sheriff Court than it does in the Court of Session?
Yeah, I mean, a general line would be it costs less to take cases through the Sheriff Court than it does to take through the Court of Session. That's why the fees at the Sheriff Court are lower than the Court of Session.
Okay, I'll let others take over.
Tempted to jump in, but I want to make sure everyone else has an opportunity. John, followed by Jean.
Thanks, Convener. I think I've just got one point because we've covered quite a lot of ground already. In the Faculty of Advocates submission, they question the general principle that parties should bear the cost of civil actions through the setting of court fees at a level which recovers the costs to public funds. I mean, could you just explain a little about why? Is that the case, that basically the costs are 100% and the parties should cover 100%? Because, for example, the railways, we do it differently. We say the public purse will pay 50% and the user will pay 50%.
It's not currently the case that the full cost recovery has been reached. I mean, it is the policy principle going forward that eventually, over time, that will be the case. I think currently it's about 80% of costs are recovered through fees. Mm-hmm. But I say that is looked at every time the fee orders come, fee orders are consulted on and then come before Parliament. There's always moved towards that full cost recovery stage.
And the argument of the Faculty of Advocates or others that it's a kind of public service, so it should have a subsidy, that's been discounted?
I mean, that's not for this bill, I would
okay,
suggest. Right. I mean, it's a wider policy issue.
But it's an assumption in this bill?
It's an assumption in the bill because that's the current policy line, yeah.
Okay, thank you. That's me.
Jean.
Just a couple of points, I think. One on, I think the word disappearance was used by Ronnie Conway about the appeal court, where there are 3 senior sheriff principals, rather, and now there's 1. I just asked about that, and also his comment that really looking at the level of business going into sheriff courts, that would require to be, and first of all, he said 5 or 6 extra sheriffs, and later 4 or 5, I think.
In terms of the...
if you could just explain the reasoning behind these changes and their declaration that you need more staff, not less.
Yeah, and in terms of the Sheriff Appeal Court for the civil side, Mr Conway was correct in saying that Lord Gill did suggest it should be 3 Sheriff Principals. I think the Scottish Government, in response to the review, we didn't agree with that, and we thought one appeal sheriff would be sufficient, because that replicates what's currently the situation with civil appeals, and it was generally heard by just the Sheriff Principal on their own. So we put that to consultation, and that was the Scottish Government's position. It was agreed by the majority of respondents that they like the kind of the benefits they have from just a quick appeals system through a Sheriff Principal. So the point of this Sheriff Appeal Court in the bill is to replicate that in the civil structure, to replicate the benefits of just having 1 appeal sheriff there. It wasn't driven by costs. I just want to suggest that, although obviously there's an effect. So I think I forgot the second part of your question.
Well, I was really asking you to explain somebody else's statement, but just that Ronnie Conway made the point that we require 5 or 6 or 4 or 6 new sheriffs.
We don't agree. I mean, I think Mr. Conway's point was on the general as a whole. I think we've covered that with Mr. Brown's questions, that we think that the sheriffs at the current level is enough to handle this level of business. In terms of the Sheriff Appeal Court, they will be staffed by sheriff principals and some experienced sheriffs of 5 years working as a kind of pool and be used as and when necessary. But we don't see a need for any extra sheriffs to be utilised or recruited. Sorry.
And finally, just you, I think both have said that IT is important and refreshing all of that, but the budget of 10,000 seems very small. I mean, presumably there's a bigger game plan.
Yeah, I think
to introduce IT.
There is a separate project that SES are undertaking, and it's obviously their IT systems. That's a multi-million-pound project they're doing. It's ongoing at the moment to introduce a brand new civil IT system across sheriff courts. So the 10,000 is only to update what they currently use until this new system is ready to come on stream. So it's only for really minor modifications to our current system. The full IT system is a multi-million-pound project. It's a lot bigger.
Okay, thank you.
Well, that seems to conclude the questions from the committee, but I've got some more I'm going to ask myself, some fairly brief questions. The financial memorandum, well, first of all, I should say this is from the Law Society of Scotland. They say in paragraph 16, the financial memorandum suggests one-off costs of £10,000 and £20,000 for designing and set up of personal injury court and the Sheriff Appeal Court respectively, developing the process, creating the training programme for appeal sheriffs and staff, and confirming the operating model, and this is referred to in paragraphs 1.3 and 1.39 of the financial memorandum. But they say that there will be significant one-off costs in creating a new training programme for specialist sheriffs and continuing costs to train specialist sheriffs in the areas of expertise. So see how you come up with these sums, and surely there must be ongoing costs in terms of training rather than just a one-off, because I mean obviously sheriffs have to be replaced and surely new sheriffs have to be trained.
Yes, I mean that's true. I mean, sheriffs are currently obviously get a lot of training. We don't expect that training need to increase. As the planning assumption in this is a summary sheriff will be recruited as a sheriff retires or leaves the bench. If there wasn't for these reforms, that sheriff would be replaced by another sheriff, not a summary sheriff, and that sheriff would go through training as a summary sheriff as well. We don't expect there to be an increase in requirements of training. They would just need the same level of training as a current sheriff would get.
Right. Okay, and how did this particular sum, how was it arrived at? This 10 and £20,000, how were these sums arrived at?
They arrived at just taking account of all the factors that were pointed out in terms of designing a training programme, doing things like that. That was kind of the ballpark figure of what would be required to do all that work. Okay, right.
Fair enough. Now, one thing from the Faculty of Advocates, actually, they've pointed out that in their view, paragraphs 118 and 155 are inaccurate and misleading, and they state, and I quote, that the Faculty of Advocates has expressed concern due to the reduction in cases in the Court of Session and High Court as a result of these reforms, as advocates have exclusive rights of audience to these courts, and they've said this is inaccurate in two respects. One, advocates don't have exclusive rights of audience in the Court of Session and the High Court, and solicitors with higher court rights of audience also have rights of audience. And then they go on to say their second point is that two features of the bill: increase in exclusive competence of the Sheriff Court and the creation of a Sheriff Appeal Court, although these features of the bill will have a direct impact on the Faculty of Advocates, blah, blah, blah. So I'm just saying, do you agree with them that there are inaccuracies in the financial memorandum in terms of these respects? And if so, are there other inaccuracies that you've identified within the financial memorandum since it's been published?
I think in terms of those specific sentences, we would agree with the first point when we say exclusive rights of audience. They are right. Solicitor advocates also have rights in the Court of Session.
And that's clear from elsewhere in other paragraphs in the memorandum. So that is simply an error.
Yeah, paragraph 85 and 132, we make it clear that solicitor advocates also. So that is an error on our part. In terms of your second point, we believe the rest of the financial memorandum is accurate.
Okay, that's fine. Well, reassuring. There may be disagreement on whether or not it is or not, but it's interesting that you're of the view that in actual fact everything else is correct. Thank you very much. Is there anything else you would want to point out to the committee before we wind up this session?
Yes, if we could just make one point regarding what the policy intention, what the government is trying to achieve. It does have a bearing on financial impact, but on the users of court services. Part of the driver for the reforms is something that Lord Gill identified in the course of his review, that the costs incurred by the parties litigating in the Court of Session are disproportionate, and it's something that we pick up in the policy memorandum, and where we say, paragraph 83, at present the amount paid to the lawyers on both sides of a low value claim in the Court of Session almost invariably exceeds the settlement figure of a claim or the amount awarded by the court. We haven't really heard anything this morning about the benefits to the court users, and I would just like to make the point that...
To interrupt you there, that was really touched on at the beginning, which is why both parties suggested that there should be maybe a £30,000 limit, because below that, that's when you did have the criteria. I think I think it was maybe just before you came in, but I think Mr Conway did actually talk about that, and that's why both the Faculty of Advocates and APIL were agreeing that there should be a transfer to Sheriff Court. It was just the level at which the transfer took place, so they did actually touch on that in their evidence.
I think it's fair to say that all those who responded to the consultation are supportive of the reforms and what is being proposed, but there is a disagreement as to the level, and I've already discussed the difference in approach to how you fix the settlement, you fix the level, as to whether you base it on settlement figure or sum sued for. But I simply wanted to put a marker down that the reason why the initiatives are being taken forward is for the benefit of efficiency generally, and for the benefit of access to justice for court users. And on there was a point made, I think, by Mr Wolffe about those cases that are not PI cases that will transfer from the Court of Session, and he questioned whether there's any financial benefit in that happening. I think I just wanted to say and put on the record that we do have, there's been quite a bit of support from consumers and small businesses who are supportive of the changes and the fact that the cases will now be brought in the Sheriff Court.
Thank you, that's very helpful. That being the last item on our agenda, that concludes the Finance Committee for today. Thank you.